Sir, before we swear the next witness, could I just take this opportunity to put something on the record, which is that there is a correction to CTI's opening statement that is going to be going onto the website overnight to address two issues. First, the position as regards the passage of information between Acorns, Alphonse R and Lancashire Constabulary on the morning of the 11th of December 2019. And, sir, you may recall that relates in particular to the hell-bent comment, which is only fair is addressed prior to Alphonse R's evidence later this week. And secondly, it also corrects the position as regards Amazon's evidence in relation to providers or potential providers of weapons, which resulted from inaccuracies in their initial disclosure. I'm not going to read out that correction now, given the time, but it will be available on the website overnight.
Thank you very much. It's important that people should know that those corrections are going to be made.
Thank you, sir.
Would you mind standing?
I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. Please have a seat. Yes, Mr. Goss.
May it please you, sir. Could you start by giving us your full name, please?
Louise Anderson.
And if we could have LCC 001855, please, Sarah. Is that your witness statement for the inquiry?
It is, yes.
It's signed on the 19th, I think, of September 2025. Are the contents of that statement true to the best of your knowledge and belief?
They are.
At paragraph 43 on page 14, you introduce LCC 201854 as an annex to that statement, which was a chronology of children's social care contact with AR that has helpfully been produced. If we could just have the first page of that up, please. Again, can you confirm that the contents of that chronology are true to the best of your knowledge and belief?
I can, yes.
Thank you. If we could start with your experience and your role, please, Ms Anderson. You've been the Director of Children's Social Care at Lancashire County Council since November of 2022.
That's right.
In paragraph 4 of your witness statement, you set out various graduate and postgraduate qualifications you hold, including an MA in social work. And in terms of career history, I think you've been a social worker since 2007 for various local authorities, including as principal social worker for City of Wolverhampton Council between 2016 and 2020. And then after that, I think a senior leadership role in Wolverhampton before moving to Lancashire, as you've said, in November 2022.
Yes.
Thank you. The first topic I want to explore with you is about children's social care, its structure, its role, and in particular its role in managing risk to others. You set out that there are various different services within children's social care. One of those is the MASH, is that right?
Yes.
As a thumbnail sketch then, what is the MASH?
So the MASH is a multi-agency safeguarding hub. It is where all contacts come into the local authority from other partners, from other organisations, from members of the public, with regards to children who might be at risk of harm. It's a multi-agency hub. It has within it police, probation, education and health. It has early help and social work staff there, and they essentially triage those contacts that come in and make decisions as to where in our system they should go, if they should go anywhere at all.
All right, thank you. We'll come back to various specific interactions with the MASH. There is the duty and assessment team in which Anna Jameson, sir, from whom you heard last week, and also Stacey Haydock, about whom we'll hear a little more today. They both worked in that team. What does the duty and assessment team do?
So the duty and assessment team have the role of undertaking an assessment to understand what is the level of need that a child has. So they will do an assessment that will identify whether a child should be open to children's social care, should become a child in need. They might find that a child meets the threshold for Section 47, and they might initiate that Section 47 process. They might decide at the end of their assessment that a child needs early help or universal or no further action at all. So they conduct the initial assessment, which is around understanding the level of need. They also do a separate task in Lancashire in which they undertake eligibility assessments with regards to children with disabilities or with SEND, and within that part of their work they would be assessing whether a child meets the eligible criteria for services as a child with SEND, or whether we should provide services to help a carer deliver their caring responsibility.
I follow. There are then children in need, child protection and court teams. That is for cases which, after the initial assessment, are kept open at what I think is now level 4 on the continuum of need.
That's correct.
So those are teams that can hold a case for longer than merely an initial assessment period to work with a child, with a family, up to and including bringing court proceedings as regards how that child should be looked after.
Yes, so they are multidisciplinary teams that have social workers, domestic abuse workers, probation workers, health workers, substance misuse workers. They're called adult workers, and their role is to work with parents to reduce risk and enable children to remain safely within their families.
There is a contextual safeguarding team. We've heard a little bit about contextual safeguarding. What does that team do?
So that team has evolved. So it's now called the Empower Service, and it's a little bit more than a contextual safeguarding service now. So that service we say that it works with extrafamilial harm. So this is where children are at risk of harm, but the primary reason for that isn't a parental factor. So it could be contextual safeguarding, risks in the community, but it could be mental health.
Whose mental health?
The child's mental health.
And you say that team has evolved. When did that team get introduced?
So that team existed before I arrived in Lancashire as a contextual safeguarding service. I couldn't tell you exactly when it was, when it began. We remodelled 2022, 2023.
Thank you. The Youth Justice Service, I think, falls under your directorate as well. We've heard about that from Ms Callan. One team that I don't think you mentioned in the overview you give in paragraph 5 of your statement is the Missing from Home team. And in particular in 2022, how did that operate?
So the reason it's not mentioned is now it is just a part of our Empower service. In 2022, it was a separate service. It's a group of people that undertake missing from home interviews, and we are required by law to have people who are independent of children to undertake missing from home interviews.
We'll come back to them. In terms of the kind of cases that children's social care are dealing with, if we can have LCC 201900 and page 16, please. This is some of the explanatory notes that sit behind the continuum of need, Ms Anderson, with which you'll be familiar. The orange flagged text at the top is in relation to level 3, and we can see that it then goes over to level 4 at the bottom of the page. In terms of level 3 indicators, they include difficulty coping with anger, frustration and upset, and a child who has entered the criminal justice system at pre-conviction stage. Those sorts of indicators you would still expect to be being dealt with by early help, rather than necessarily meaning that this was a child in need or higher. Is that right?
That's correct.
And then if we look at the level 4 indicators, and bear in mind that level 4A is the lowest of the levels within level 4. As a general point at the top, if you suspect a child is suffering or at risk of suffering significant harm, self-harm, and or at high or very high risk of harm to others, follow child protection procedures. So the risk of harm to others is clearly a relevant factor in terms of whether a child is a child in need or in need of a child in need of protection, if I can put it that way.
So I think this needs some context, if that's okay.
Please.
So I really have wanted and have been looking forward to the opportunity to really talk this through and where social work sits with this. So social work legislation, the Children Act 1989, was originally created to safeguard children against interfamilial abuse and neglect, severe neglect. As time has gone on, those lines have become a little bit more blurred. But as you work through our legislation, there is a strong line around abuse to the child that social workers are focused on. So as a social worker in training, most of my training was absolutely about protecting children from risk of harm by their parents. We've moved on, and we now think about risk of harm from adults, but abuse and neglect is at the centre of what we do in children's social work. It's been interesting as we've talked about this comment around risk to other, which for me is really a public protection matter. It is something that social work is involved in, but I think it is inquiry that it's really important that the inquiry understands that it is not our primary focus up until this point. So at the moment, our primary focus is always on, is this individual child at risk of harm? And that comes through as you work through our legislation in a bit more detail. So for example, children who are subject to child protection plans become subject to a child protection plan under a category of abuse. And those categories of abuse might be physical, they might be sexual, they might be emotional, but we have to name a category of abuse. And so most of our legislation pushes us to be thinking, is the child you are working with suffering harm? And so I agree with you that this is written here, but I think the context of understanding our profession and what it was built on and what is our primary role is really important as we move through today. And we'll probably talk more about that.
We will. Because this is these are the indicators for the Lancashire Continuum of Need, as I understand it, as
Yes.
it was in place from 2021.
Yes.
If we can go to the next page, please, Sarah. And if we could expand the safe from harm box. The indicators here, the first indicator under this category is challenging or disruptive behaviour putting others in danger, isn't it?
It does say that, yes.
And there is likewise regular involvement in criminal or antisocial behaviour and parental refusal to engage over concerns. And if we then go on to page 17, the level 4B indicators, again, we have the same general comment at the top. If you suspect a child is at high or very high risk of harm to others, follow child protection procedures. And then again, over the page. And the safe from harm box, please. We see a number of the same indicators as we saw at the lower level, but then also child assessed at high risk of harm to others as a result of offending behaviour. About a third of the way down, CYP assessed as high risk either to themselves or to others. And then also in there we have poor or abusive parental relationships chronically socially excluded or extreme isolation. And I just bring those out now because they're ones we may want to have in mind as we go through. But even in 2021, and bearing in mind the very helpful context that you've given about the history of some of the legislation and the culture of social work, the risk of harm to others was clearly a factor that children's social care needed to have in mind when thinking about how to assess a child and the level of risk around a child. Is that right?
It is, yes, and would be taken alongside various other factors within the family and the home environment.
Yes. You've touched on some elements of the statutory framework. You've set it out very helpfully in your witness statement. If we could have that back on screen, please, Sarah, at starting at page 2, 1855. You've set it out over almost 10 pages of your witness statement, Ms Anderson. I'm not going to go through it line by line, but just briefly, 3 key sections I wanted to ask about. First of all, section 17 of the Children Act. Help us with that.
So, section 17 of the Children Act is a large area of work, and in the Children Act, it's actually quite vague and very broad. As you move through into working together to safeguard children, we start to see the specifics of that. So in the Children Act, it really covers everything we do, including early help, through to our more statutory services. And it's really when we get to working together that we start to see a little bit more clarity around what might be the work of early help and what might be the work of children's social care.
We'll come to working together shortly. You've mentioned section 47 already, often mentioned in the same breath as section 17 as well. That is, in effect, a form of statutory inquiry where where there are reasonable grounds to suspect a child is at risk of significant harm.
It's a child having experienced significant harm or likely to experience significant harm.
And the outcome of a Section 47 inquiry can be intervention by a local authority up to and including under Section 31, which is the power of the court to make care orders.
Yes.
While on Section 31, that defines harm as ill treatment or the impairment of health or development, including, for example, impairment suffered from seeing or hearing the ill treatment of another.
Yes, it's severe impairment.
Could that kind of harm include a child putting themselves into a dangerous situation by virtue of their own actions?
Yes.
One example might be if they are seeking to harm others, they are exposing themselves to risk of physical harm through self-defense or retaliation.
Yes.
And more broadly, they may also be bringing harm on themselves through exposure to adverse experiences such as custody or being brought into the criminal justice system.
This has been a really interesting form of inquiry and just something that I was hoping to have a conversation about. So, in my career, we have never considered the risk of being in prison as something that we would consider as something that would equate to significant harm. It's been a really interesting line of inquiry, and I think I absolutely agree that a child going to prison is harmful. But in terms of the way that we work in child protection, we haven't really thought of that, in my opinion, as a form of significant harm, and I really just wanted to share what that would mean for our profession if we were to. So 140,000 children in the UK between the ages of 13 and 17 are believed to carry knives. 3,698 knife offences in the UK for that age category. There are children who are at risk of committing other offences like sexual assault, physical harm, or different types of physical harm, drug-related and burglary-related.
Ms Anderson, I'm grateful for the detail. I think that the answer to the question was that that would be a form of harm to the child, but
not significant harm.
Whether it would be significant harm or not might depend on the duration or the circumstances, but I think your answer is that effectively child protection services are simply not set up to consider the level of risk that might arise, or that kind of risk.
I don't think it's the primary work of children's social care to...
Would you agree with this as a proposition, that if you have a child who is posing a risk of harm to others, perhaps from carrying a knife, perhaps from expressing an intention to use it, it's very likely that the people who are at risk in that situation are going to be other children?
Quite often they are other children.
And by not addressing, at the point you can address it, with this identified child who poses a risk, the risk of harm to other unidentified children simply goes unaddressed.
So, one of the other things on this point is just being clear about the other mechanisms that are in place to manage that risk,
yes,
that children's social care work with. So there are a number of other places where we manage that part of the risk within our system. So to be clear, public safety in terms of violence, right up until 2022 sat squarely within the realm of public health. Post-2022, and when we came out of lockdown, we began to have more conversations about that in social work, and in Working Together 2023, there is a shift with regards to violence and the role of the social worker, and that was very much linked to contextual safeguarding. But the other places where we work together on this are in places like MAPA, through our Youth Justice Service in terms of prevention and diversion. We have MASPs, and these are all other places, and of course Prevent, and these are all other places where we together as a multi-agency system look at managing children who are at risk of harm to others.
The challenge with that, I'd suggest, is that certainly in the period that we are looking at, but also perhaps to an extent now, the challenge with that is that very often it is children's social care leading a child protection process that is focused around questions of risk of harm to the child, as you've described, and that is making decisions about whether thresholds based on risk of harm to the child are met. And is there not a danger in that situation that the fact that a child poses a risk of harm to others becomes downgraded, diluted, or overlooked?
So what I'm saying is that in those other meetings, like our MASP meetings and the MAPA meetings, those agencies have a duty together to assess what risk that child poses to other people. They are multi-agency meetings that usually include, similarly to child protection, they include health, CAMS, FCAMS, police. They are police-led, because they are dealing with matters of whether a child is about to commit a crime. And that is where those risks are clearly named and clearly managed by the partnership.
The risk, or the criteria for a child to be within MAPA, though, is typically a custodial sentence having been received. So you're already dealing with a very high threshold before those procedures are able to take ownership of that risk.
That's correct.
Below that level, do we not again run the risk of falling between two stools as a child protection multi-agency framework essentially, as we saw in this case in December 2019 to March 2020, takes the lead, and the result of that is that risk to others is seen as a less significant, less important factor or overlooked entirely?
I agree, but in 2022 there was new legislation that created MASPs, and MASPs are for the...
Help us with what that stands for.
Multi-agency safeguarding... Can I send it to you later? Sorry.
By all means.
So they are places where anyone can make a referral. They are police-led. I do have it written here. I'll find it you in a second. They are police-led. They receive referrals from schools, children's social care, from police, etc., youth justice. And they are a place where children who are at risk of being criminalised in a number of ways, that risk can be managed by a multi-agency group. And there is... Have you heard about prevention panels yet that are being trialled at the moment?
I don't think we have. I think we're at risk of moving on to questions of what the system is now. If we could come back slightly to the system as it was when in the period that we're dealing with. We've talked already about some of the points I wanted to come to, which I think is going to let us move slightly faster through them. Could we have LCC 201898, please? This is and I may be at risk of committing the very sin I've just called out, but this is the December 2023 Children's Social Care National Framework. Was there an earlier version of this?
No.
Okay. Could we look to page 13, please? It's a helpful one-page summary. It underlines, doesn't it, the extent to which children's social care is centred on the welfare, wishes and feelings of the child themselves. Is that right?
It is, yes.
We ought to bear in mind that the welfare of the child doesn't simply mean doing what the child says. You're nodding your head.
I agree.
Because there can be cases where the welfare of the child firstly might be best advanced by something that they don't want. There might also be cases where even though the welfare of the child is obviously crucial, paramount, as it puts it in the first principle there are other needs that ultimately outweigh it.
Yes.
And we've talked a little about how, in some cases, that might be the needs of other unidentified children. There may be cases where, for example, a child needs to be removed from a class at school because they pose a risk of physical harm, sexual harm, or indeed a risk to the education of other children. Again, you nod your head. Just only for the transcript, Ms Anderson, we need to have your answer on the record.
Yeah, I understand that, although I'm not in education, but yes.
And consistently with what you have told us, neither in this document nor in the 2018 version of Working Together to Save Children does it address the potential risk of harm from children to others, does it?
No, it doesn't, as far as I know.
At that time, so looking at 2019 to 2023, if it was not children's social care's responsibility to identify or address those risks, whose responsibility was it?
So if we think about expertise in terms of that multi-agency group, I think we've already heard that FCAMS are the agency that have the training to be able to assess whether a child is a risk to another person or not. And so they are key in that role. I think we've already heard that police have powers in terms of investigation to understand if a child is participating in criminal activity or spending time with other people who are participating in criminal activity. Our youth justice service at the time was just beginning to move into the prevention and diversion space. So in 2018, the prevention arm of youth justice was launched, and I believe maybe 2 years later, the diversion arm was launched. So there were a number of agencies who would lead on the identification and then the work and intervention.
And again, at that time, is it right that the only formal multi-agency forum to bring all of those agencies together would have been the child protection process under Working Together to Safeguard Children?
In this case, no, because there would also have been Prevent.
Okay. We know that, of course, but by that I take it you mean the scope for a channel panel bringing together multiple agencies.
Yes.
We know that in this case it was never taken on to a channel panel. Putting that, therefore, slightly to one side, acknowledging it would have been possible had the case been taken on.
Yes.
Without that mechanism intended to address the risk of radicalisation, was there any other multi-agency forum to bring those agencies together to look at risk to others other than child protection multi-agency work under Working Together to Safeguard Children?
Not consistently across the country. So in some areas, yes, okay, but not all.
In Lancashire?
I don't think so. I'm not 100% sure where Lancashire were at with their multi-agency exploitation work at the time.
If I can put it this way, we haven't seen any evidence that there were any other multi-agency forums either engaged in this case or that were considered to be engaged in this case, putting Prevent to one side. That would suggest that the answer to the question is no.
Agreed.
It was only Working Together to Safeguard Children, wouldn't it?
Agreed.
And that then does create the risk that I was trying to put to you earlier, that where you have a forum which is wholly set up around a child protection system focused on risk to the child, risk from the child ultimately doesn't receive adequate attention.
It might not, but in an ideal situation, the contribution from CAMS and their assessment into that meeting, and the contribution from police and their assessment into that meeting, and latterly the contribution from youth justice into that meeting, should really make sure that risk to others is also considered.
We'll come to how that process operated shortly. But before we do, can I just deal briefly with the way children's social care in Lancashire in this period understands and transmits information. You've mentioned the assessments carried out by the Duty and Assessment team. That's a child and family assessment primarily?
Yes.
I think there is also, as you say, a carers and needs assessment, although in this case, ultimately there were 2 child and family assessments done.
No, so there was one child in need assessment done.
Yes.
And then there was one carers assessment completed.
Okay. They were, I think, both produced though on a child and family assessment form, which perhaps was a paperwork error.
Yes, but some authorities don't, although they are different assessments, some authorities don't have separate assessment forms or didn't back then.
2 assessments, though. One in February 2020 by Ms Jameson and one that was completed in September 2021 by Ms Haydock.
Agreed. The difference in what the social worker's role was to do in those assessments is really key.
We'll come on to the specifics of the assessment. For now, I just want to trace some of the information flows. As well as those assessments, there's also the general case notes for the child, and we've heard that there is essentially a children's social care element of liquid logic, or LCS, and a child and family wellbeing element of it, the early help module. When children's social care are engaged, that should record certainly all substantial contacts involving the child on that system. Is that right?
Yes.
I think Ms Jameson candidly accepted that her note-taking was not adequate in the period that she was involved. A number of contacts not recorded, and the notes that were made not recording key information. For example, AR's comments about the Manchester Arena bombing being a good battle. In Ms Haydock's statement, LCC 201772, page 15 and paragraph 67, she says, I regret and I'm disappointed with myself that I do not seem to have kept comprehensive notes of my meetings with the family. Is it concerning that both of the social workers within the duty and assessment team who completed assessments in this case did not keep adequate notes?
Sorry, could you say that again?
Yes. Both of the social workers within the duty and assessment team who had contact with this case have accepted that they did not keep adequate notes. Is that concerning?
Yes.
Is it a sign of a wider issue over note-taking, record-keeping within children's social care?
I don't think so. So, Lancashire County Council, as you will have read in my statement, has over this period of time been on quite a large improvement journey. At the beginning of this work, in 2019, the local authority had just become requires improvement to be good. And that was where that authority was at the beginning of this. In November 2022, they had made some significant improvements and became a good local authority. However, I know that our systems and recording is improved even more since then for lots of reasons that I'm sure I'll come to. So it is disappointing. It is likely that that was a concern at the time, given where they were in their inspection judgment, but I don't think it is the current case.
Can we look at one of Ms Haydock's assessment, LCC 30247? We've spent some time looking at Ms Jameson's assessment, Ms Anderson, and so unless you want me to show you specific parts of that, I will summarise it. Ms Haydock's assessment, if we go to page 2, page 3, it refers in the course of this assessment to the facts underlying AR's convictions, which of course were around about 18 months earlier at this point. It doesn't mention the fact of the conviction itself, and it doesn't, in contrast to Ms Jameson's assessment, record AR's intent to kill. And ultimately, despite recording recent examples of AR's extreme reactions, it talks, as you'll know, about while a social worker was there, AR pouring milk over his father's bed, his parents' bed, because he'd become upset. It doesn't record any concerns that services may be required or the child may be at risk due to socially unacceptable behaviour. When looking at the way in which this assessment in 2021 draws or does not draw on the earlier assessment in 2020, Is there a risk that important information is becoming diluted or lost as we move through the system?
So this was a carer's assessment, and it was an assessment that was about, does AR and his brother have eligible needs for services? And those services would have been things like direct payments, PAs, personal assistants, those types of things. So I think that context is important, but also social workers are really asked to think in their assessments about the information that they're providing, and they're asked to think carefully about historic information and whether that should be in that particular assessment or not. I agree with you that not seeing it in here, and I agree with the comments that you've made throughout this process in terms of dilution of risk. But whether it should have been in this assessment or really clearly in a chronology are two different matters.
The difficulty with that is a number of LCC employees have referred, for example, to going back and reading for previous child and family assessments, effectively treating them as a way into the case. And so if those, because of the function that they have, are not recording all relevant information, then that is where the risk then comes that information is lost. Is that fair?
It is fair, but what we should have is a really good, concise chronology that outlines risk factors, which means that when somebody picks up the child, they are able to see really clearly what significant events have happened and what those significant risks have been. That would be a more concise way to make sure that we transferred the facts. It would mean that they didn't have to read all of this. That's where it should be, in my opinion.
It's where it should be. It isn't where it was in this period.
I agree.
Is it where it is now?
We are almost there. We are much better than we were. And we're actually now about to use AI to make sure it's perfect. Thank you.
I want to turn now to some of the specific episodes of CSC contact with AR. We know that on the 7th of October 2019, Lancashire Constabulary made a high-risk police safeguarding referral to the MASH as a result of AR repeatedly carrying a knife to school and indicating that he may use it. Again, we've looked at the referral a number of times, and I'm sure you will be familiar with it. But the officer identified that this shows potential for huge escalation, and it was obvious cause for serious concern. That officer was not wrong, was he?
No.
By lunchtime the next day, the case had been stepped down to level 2 for early help. There was then further information received from David Crugine of the Range High School the same day, reporting in effect the same incident, but from the school's perspective, they having been alerted by the police themselves. But adding the further information about AR having recently said that's why teachers get murdered following receipt of a detention. And again, he expressed concerns, great concerns, about the risk AR posed to himself and others. And again, he was not wrong, was he?
No.
But there was no reassessment, and this was simply left as open at level 2. Given the level of risk, given the kind of risk, identified by 2 different agencies, would it have been, first of all, at least open to the MASH to have referred it to the duty and assessment team within CSC rather than stepping it down to early help?
So I think here it's really, again, a really interesting point, and there are some things to balance. So firstly, the issue of it being stepped down straight away to early help. So in terms of what the social worker was dealing with in terms of information, there would have been some things that were a factor there. The main thing being that this was a child who had never been known to children's social care before. And usually, in our practice experience, it's uncommon for children to go from 0 to 100. So no behavioural concerns before, etc. The police did describe him, and I know that that was challenged later, but the police described him as having an appropriate response. He was crying, he was upset. The reason being bullying the reason that he was saying he was going to do that, being bullying would have played a part in their thinking. And the fact that mother had said that she was going to make sure that the knives were put away would have created some instant safety. Then the other bit is about the people in our system who work well with children like AR, and they are usually, at that time, workers like youth workers who are fantastic at building a rapport and diverting children. We also have our intensive family support workers who sit down with children and do the behaviour work. And so the people in our system, in terms of the plan that we thought that social worker probably thought would make a difference, they sit in early help. So I understand that thinking. If you look at the 2019 con, I could see how there were elements of what was level 2 in that 2019
Yes.
that he would look like he fitted, but I agree there are also parts of that level 3 that he looks like he fitted as well.
So the answer then is that it would have been open to the MASH to hold it at level 3 as would have been, but equally you would say that the decision to step it down to level 2 was one that you can understand.
Yes.
Thank you. By the time we get to the 6th of December 2019, there's been just under 2 months of attempts by early help to engage unsuccessfully. There's further concerns from Acorns, which they shared with the MASH, about AR's inappropriate behaviour on the internet, searching for violent imagery, school shootings, guns, asking about access to pictures of beheadings. And there had also been, at the meeting a day or so beforehand, very obvious concerns about Alfonzar downplaying or minimising AR's behaviour. If we can see LCC 4024 on page 5, please. And at the very bottom of the page, we can see the response from the MASH received on the 6th, and then just over the page for the actual content of it. Response from a MASH education officer. The concerns do not present as level 4. Concerns regarding AR searching on the internet for violent images can be managed with level 2 support, such as police community safety officer and emotional well-being services /CANW. Do you think that was a appropriate assessment at this stage?
Yes, our early help workers absolutely can work with children around not accessing violent images on the internet, trying to divert their attention, get them interested in different matters. And yes, I would expect the police community safety officer to be able to do some direct work around the other elements that we're talking about.
It goes on to say, children with autism, which AR may have, often develop obsessions around death, violence and crime. This is due to their neurodevelopment. Wasn't sure whether AR was being assessed for autism by the community paediatrician. There's no apparent recognition there that in some cases an autism spectrum disorder combined with a fixation on death, violence and crime can become extraordinarily high risk, is there?
there isn't, and I agree with you that that is something that we need to make sure is understood. So at the time, there was some research that was being produced from universities that was talking about the risk of criminalising children with autism and misunderstanding them because of the way that they present and sometimes talk about these types of issues. They were overrepresented in Prevent, and there was concern about that. And the messages out to the workforce at the time were about don't misunderstand this child with autism and don't necessarily make a referral to Prevent, because there was a sense that the traits that some children have with autism make them look like they could be a risk, but they are not. And so I agree, it's really important that we understand that for some children, where they have autism and similar traits in their behaviour, and then also are fixated on violence, there is increased risk.
And that wasn't properly understood at this stage by this person?
I don't think it was well understood across the whole system at the time.
You said that, my summary, this was an appropriate way to deal with this issue at this time. There doesn't seem here to be any connection to the earlier October incident with carrying knives, or the fact that Early Help are in fact the ones who have pointed the school in the direction of the MASH, or the fact that Early Help have spent 2 months trying to engage with the family without success. Do you really think this is an adequate response to the level of risk that AR was presenting with at this time?
So when I looked at the file, I was concerned at how long it took Early Help to start their work with the family. As you know, we now do 7-day visits and we engage families quickly. We know that that helps with engagement. I don't think that the slow start was solely the fault of the family on reading this file. The important thing, though, is the plan and whether the workforce was trained and equipped to deliver the plan. And I believe that non-qualified workers absolutely can do really good direct work on these points.
The reality is that AR was at such high risk at this point that 5 days later he did in fact carry out an attack on a pupil at the Range High School with weapons, with a knife in his backpack, saying that he would use it if the hockey stick hadn't worked. He was very high risk at this point, wasn't he? And that should have been recognised.
With the benefit of hindsight, he was high risk, given the amount of children that we work with who present with these types of behaviours. So let's not forget the amount of children that carry knives. We have some children that say they will use a knife and never do. And we have many children who would look me in the eye and tell me I will never use a knife and do use a knife. We provide resources on this to designated safeguarding leads, early help workers, lots of people who are not qualified, youth workers. And so I think that the plan around those workers doing the work, I know it wasn't effective. I think it could have been effective.
Can we look at LCC 202302, page 12, please, in the bottom entry? This is just after the attack. It's the day after. Because Ms. Halloran, who was the mental health nurse in the criminal justice liaison and diversion team, if we could have the last complete entry on that page expanded, please, Sarah. She attempts, having dealt with AR in custody after he's been arrested for that violent offence, and where he's caused harm to another child. She tries to refer it to the MASH. And you'll see 5 lines up from the bottom. Stephanie shared that she had spoken with MASH and they would not accept the case at level 4 and that it was open to CFW. Accepting that the case was shortly afterwards stepped up after Child and Family Wellbeing spoke to the MASH, to the duty social worker. The picture that starts to emerge here, Miss Anderson, is a MASH that is wholly reluctant to accept any case based on risk to others. And instead always seeks to step it down and push that responsibility away from CSC. Is that fair?
I don't think so.
What possible explanation could there be for the MASH on the 12th of December refusing to accept the case at level 4, where AR has carried out a violent attack on another pupil with an intent to kill, has caused harm to his victim, and where he is, at this point, either in custody or just out of it?
Sorry, apologies. I thought you were before the incident, not after.
No, this is just after.
And apologies, I haven't seen this one before. I would obviously expect the MASH to take and accept a referral when someone has just committed a crime.
Yeah, that was a wholly unreasonable approach to assessment by the MASH at that stage.
Yes, and it's strange because we obviously would receive the PSR from the police and then begin.
And being fair, Ms Anderson, as I said, we must recognise that it was very shortly afterwards stepped up and that the duty and assessment team became involved. But as an initial response, that was wholly unreasonable.
Agreed.
We've heard from Ms Jameson directly about the child and family assessment that she conducted. Could we look at your witness statement, LCC 001855, page 41? And I want to pick up here on what you said earlier about different agencies having the expertise or the lead on risk to others. Paragraphs 166 to 188, please. You characterise Ms Jameson's assessment as rightly including information from Prevent, the police, CYJS and FCAMS. These agencies provided information pertaining to the level of risk AR could pose to others and what work should be done with him as a result of this. Just working through those, Prevent had said, we don't think this is a case that reveals a risk of radicalisation, though he is clearly very vulnerable. So they were not providing any input other than saying we don't think it's a radicalisation case. Is that fair?
Agreed.
At the point that the assessment was done, 19th of February 2020, Crime and Youth Justice Services were not or would only just have become engaged because that was the date the referral order was imposed. So they didn't have any meaningful input into this assessment. They hadn't, for example, been invited to the strategy meetings that had taken place in December and January.
Yes.
The police, Lancashire Community Safety Team, hadn't been invited back to the second strategy meeting, and Merseyside Police were of the view that given that AR didn't live in their area, their responsibility was limited to the criminal investigation that they were conducting. So that there was no meaningful long-term input from the police as to these risks, was there?
No.
And FCAMS, though there'd been a meeting with FCAMS on the 21st of January, had effectively said, this is something that we can leave to CAMS. They hadn't provided a risk assessment and they hadn't provided suggested interventions.
Agreed, I understand that from here. What I saw in the assessment was a recommendation around what they thought the work that CAMS should be doing I didn't know before that they didn't have a detailed risk assessment.
The work that CAMS were doing, the update that Ms Jameson received prior to completing her assessment, other than, of course, the fact that AR was still awaiting an autism assessment and diagnosis, was essentially, I feel that in time he will be able to get better at dealing with social interactions. It didn't suggest any interventions and it wasn't a risk assessment. Accepting that those other organisations, of course, have a part to play, there was no process here in this assessment by Ms Jameson of drawing together risk to others and ensuring that that was included in what was going to be the only central assessment of this child.
Just trying to recall the information from FCAMS. I think that FCAMS had said that they did believe that he was a risk to others. I think they had said that it wasn't for them because he didn't have a mental health issue, but that they felt that CAMS should be doing work with him. And I can't remember the exact sentence. I think it was wider than what you just said. And I think that led the social worker to believe that the work that CAMS would do with him would address the needs identified by FCAMS.
By the point CSC became involved, because they, of course, took part in the Child in Need meeting on the 4th of March, they were assessing AR as medium to high risk, and a key element of that was the fact that he wasn't attending school, and therefore there was a lack of opportunity. Do you think that there would have been a continued role for CSC at this stage?
CSC?
For children's social care at this point?
At the end of the assessment, when it was stepped down?
Yes.
Again, I'm just going to talk about the plan that was proposed at the time. So I felt that in terms of the violence and the knife crime, that it was the role of CAMS and the Youth Justice Service to address those needs. His neurodiversity needs were being met by SEND, and his educational placement needs were being met by education. So the outstanding social care needs were around his isolation and supporting accessing the community. And so again, the people in our system who are good at meeting that social care need are in early help. They are not really positioned in the same way in the higher end child in need. So given that those were the two identified social care needs, I think it was right for early help to deliver those.
Looking at paragraph 188 of your witness statement on the screen, first sentence, with hindsight it is recognised that a more robust multi-agency plan with clear monitoring arrangements should have been developed to address the risk. If you'll forgive me saying so, there's two examples of the passive voice in that sentence. When you say it is recognised, do you mean this is your view?
So I was trying to be helpful when I wrote that sentence because I've been a social worker for well over 20 years, a lot of experience. And social work and our knowledge has moved on since 2019 to now. So I was pointing out some things that I think would have made the plan stronger.
Yeah, Ms Anderson, I'm going to ask you to answer the question, please. When you say it is recognised, do you mean that is your view?
I do mean it is my view.
And when you say a more robust multi-agency plan with clear monitoring arrangements should have been developed, who should have developed it?
So I just want to be really clear on this point. So the plan that I suggest is not necessarily one that I would have expected a social worker to suggest in 2019 with the level of training on this subject that we had and where we were at as a country in terms of understanding internet safety, etc. So it's absolutely what I would expect a social worker to do now. I'm not sure that this matter that the training had been made available at that time across our systems. But it is what I would absolutely expect now.
Would this have been a moment with an assessment of AR as medium to high risk, one of the main protective factors being lack of opportunity? Would this have been a moment for a Section 47 inquiry on the basis of suspicion as regards significant harm?
No.
Why not?
Because we didn't have evidence that he was at risk of significant harm himself. There were no immediate actions to be taken. So when we do a Section 47 inquiry, it is about taking immediate action to safeguard the child. So there were a number of actions that might happen as a result of that. The local authority, if a child was at risk imminently, we might go to the court and ask for an EPO. The police might use their police protection powers. The police might take criminal action. They might, as part of their investigation, decide that they are going to take action against the adults. We, in some cases with exploitation, might have to take an immediate action in terms of place of safety. So we use Section 47 inquiries to make sure that nobody is immediately going to be harmed, significantly harmed.
If I was to suggest that, given that the sole multi-agency forum at this point was the Child Protection Forum under Working Together to Safeguard Children, the responsibility really fell to the lead agency in that, which was Children's Social Care. You wouldn't accept that, you disagree?
I'm not sure I understand that question.
You're saying that a more robust multi-agency plan should have been developed. The only multi-agency forum for this is the child protection one that has been operating to this point.
Yeah.
And then the lead agency within that, Children's Social Care, effectively steps away. It's the lead agency within that existing multi-agency forum that should be coordinating, guiding, ensuring that that robust multi-agency plan is put together.
So that's not my view. So at the time, if there wasn't a role for children's social care, and I've just listed what the needs of the child were and how they could be met, and even the other things that I say that I think would have been helpful in terms of somebody doing direct work with him to divert him into another area of interest, in terms of someone doing direct work with him around monitoring that his interest in serious violence, all of those things could have been achieved through the early help plan that he had. It wouldn't have needed, in my view, a social worker to allow those things to happen.
All right. I'm going to move now to the June to September 2021 period, which is the next time CSC have any significant involvement other than through the Crime and Youth Justice Service, Child and Youth Justice Service. This is the point where Alphonse makes his statutory request for a needs and carers assessment, and you've spoken a little bit about that. We've got that at LCC 30108, recording the request and how it's handled. We don't need to bring it up. It comes to the duty and assessment team, and it comes to Ms Haydock. In the course of that assessment, it came to her attention that AR had made a number of allegations of violence against Alphonse, his father. Ultimately, those were assessed as being either unfounded or at most extremely historic, relating back to when AR had been a small child. It doesn't appear that any link was made to the January 2021 report of violence in the home that had been recorded by Child and Family Wellbeing and the Child and Youth Justice Service. Ought those dots to have been connected?
They would, but I'm not sure they would have made a difference.
There were a number of signs during the assessment that AR himself was still struggling with extreme responses. I've touched on one of them, pouring milk over the bed. And the information that CSC received was that AR used to throw plates at his father, but would now throw water instead. It was obvious then that AR was still unable to let go of real or perceived injustices. And there's still concerns over access to knives, because that's a topic that Ms Haydock explored with Alfonso, who refers to them only having one knife available in the house. Do you think that those sorts of factors should have cued, and again, bearing in mind all you say about the purpose of this assessment, should those factors have cued some concern within CSC as to how this case should be handled?
So, 2 points. You're absolutely right. This was a completely different type of assessment. It wasn't an assessment that was about assessing risk of harm at all. But being a social worker, if you see risk of harm, then you should do something about it. That said, I think there is some further context that we need to understand about the everyday life of a social worker. So we work with a lot of children with autism. There are 5,000 children in Lancashire at the moment with autism as their primary need, with an EHCP plan. What we know is that if you look at various reports, anywhere between 50 and 60% of parents report violent outbursts from their children and aggression from their children. When we are considering risk, we think about frequency and severity. And sadly, many parents with children with SEND needs, autism needs, and there's been national conversation about this, many parents face real difficulties in their home in terms of behaviour at a much higher frequency and with much greater severity. And so when a social worker, and by this I mean children who are regularly damaging the home and who are regularly assaulting and causing harm to their parents. So child and parent violence is huge in this country now. And I can, in Lancashire, we now have a programme for parents that is all about child and parent violence and how to manage that. So, yes, very concerning when you take on everything that we've seen for this child, but for a social worker who is seeing much higher levels of frequency and intensity, this wouldn't have necessarily triggered her to think, I need to do something like a Section 47.
We've got a number of indicators here, and we looked at them, what they were earlier on the continuum of need. We've got chronic social isolation, refusing to leave the home. Mm-hmm. We've got an obviously poor family parental relationship. Mm-hmm. We've got those elements of violence in the home, though, bearing in mind the context that you have just given us. We've also got the history, the forensic history around violence outside the home as well. Was there not an opportunity to recognise AR here as a child in need or a child in need of protection?
Yes, there was an opportunity. I think everything that I've just said just stands. And again, isolation, sadly, we are working with many children with autism that absolutely are isolating themselves. So we talk about the impact of COVID, and I know that you haven't talked about that with me, but the impact of COVID on children who really struggle to be in the public was huge. And there is a generation of children that we talk about who we say never returned. and there are lots of them. So again, what we were facing here, what the social worker was seeing, wasn't uncommon because we had a number of children that hadn't returned to school. The numbers of children in this country that are not in school right now are huge. 140,000 children not in school today. They are really, really big. And what we were seeing, it was with children with autism, when we came out of lockdown, we really struggled to get them back into school. So their sensory needs are such that they found it difficult.
Yeah. One thing that was identified by Ms Aldred in the course of this assessment to Ms Haydock was that AR would require a very skilled, trusted professional to slowly build a rapport with AR at home for approximately 3 to 6 months, as the main barrier for AR is distrust. Maggie felt it would, Ms Aldred, felt it would take approximately 12 months for AR to be ready to access social activities and would need a graded approach. You're nodding, you're familiar with that element of the report.
Yeah.
Ms Haydock's plan was for that to be met via a carer.
Yeah.
But ultimately that was downgraded as a plan to effectively say this can be met through targeted youth support. We've heard that targeted youth support was really never going to be more than at most a 6 to 12 week programme. You've suggested having targeted youth support carry that out appears to be a rational decision. Do you think that was perhaps somewhat overly optimistic? So
2 things, though. So one, it wasn't downgraded, it's a parallel type service. So
my word, and
okay.
if that is the wrong word and I'm being disrespectful to targeted youth support, then there's certainly no intention of that.
No.
But the plan was altered from one that potentially could have been in place for a sustained period of time to one that was inevitably going to be highly time limited to far less than AR's teacher, who perhaps was one of the professionals who knew him best, thought was going to be necessary.
So I agree, and I think I've said some of this in my report, and I know that you want me to absolutely make this point. So if he had had the support worker, I just want to be clear what would have happened. He would have received potentially a direct payment. Dad would have appointed the worker to do that work, and he would have closed to children's social care with an annual review. So I just want to be clear what that process looks like. It was never going to work with a 6 to 12 week programme, and I agree with you that either we should have used the support worker or we should have been clear with early help that this was a piece of work that was going to take 6 to 12 months. I think that the team around the child could have worked really well if CAMS had worked with the youth worker, which is what we would want them to do now, and help them do the work with AR over a 6 to 12 month period. So in theory it could have worked really well, it didn't, and it was never going to work for a 6 to 12 week period.
Right, thank you. I'm going to come now to the March 2022 missing episode, and I'll cover that and then perhaps we'll take a break. There were 2 notifications received from the police about this episode on the 17th of March 2022. One that related to AR going missing, that was the one from PC Fairclough that we have, and again we've looked at it a number of times, Lank 4088. And as I understand it, that would in effect go direct to the missing from home team, and they would conduct a return home interview once it was updated with the fact that AR was found.
Yes.
Then secondly, there was a high-risk police safeguarding referral raised by PC Rhodes after AR was found and returned to the home address. And that is the document that refers to AR's possession on the bus of a knife, to his intent to stab somebody or to get social media accounts deleted, and to AR having made poison. And there's some issue over made or whether he simply referred to it. That report refers to him making it. Yeah. And that was considered by the MASH and closed at level 2 after unsuccessful attempts to contact AR's parents. Is that right?
Yes.
That's the one we have at LCC 30157. So you may recall we looked at this with Ms Chapman.
We did.
If we could have page 44 of your witness statement up, please, Sarah. Paragraphs 208 to 210. As Ms Chapman candidly accepted, you also accept that the first strand of that process was badly inadequate.
Agreed.
She didn't have enough information about the circumstances of AR going missing and then being found. She didn't challenge AR sufficiently in the interview, including when he obviously lied about not having a weapon. And your view is, paragraph 210, exploration of these issues should have led to a safeguarding referral from the missing from home worker.
Agreed.
Would you accept that it went rather beyond this, Ms Anderson? First of all, the expectation on missing from home workers to conduct up to 8 return home interviews per day inevitably meant that they were unable to properly prepare or explore issues adequately.
So I agree, but we come back to the issue of so with the missing from home, in that workload of 8 children, and it wouldn't be 8 every day, I don't believe. Within that context, there will be some that are more complex than others, and there will be some that are just not known to us at all. And so a worker wouldn't have to read extensive histories on every child, but we now absolutely make sure that our missing from home workers have the history before they go out.
As at 2022, the system was one which treated return home interviews as little more than a tick box exercise. Is that fair?
I wasn't here, I can't say.
You're speaking as the Director of Children's Services, giving corporate evidence on behalf of the Council. On the evidence that you have heard about this, it treated them as little more than a tick box exercise, didn't it?
That's not my understanding when I arrived at the Council.
At paragraph 211, just below here, I think you accept that there was also a failure within the MASH to consider this case properly. AR's historic involvement with children's social care and early help should have been more thoroughly considered. It would also be expected that the MASH would have initiated a conversation with early help and missing from home, including consideration of the detail supplied about this incident. Just unpicking that slightly, what we have here is 2 referrals from the same agency on the same day about the same child and the same incident, and they should have been linked and considered together. Is that right?
Yes.
And there's no evidence that that was done, is there?
No.
But the information on PC Road's high-risk referral, in and of itself, should have been treated more seriously, not just closed at level 2 when there was no response from the parents.
Absolutely.
And as you go on to set out at 212, had any of these failings in either strand not occurred, you would have expected AR's case to have been looked at in more detail, further assessed, both in terms of risk to himself and risk to others.
I would have expected a strategy discussion.
Yes, I think we don't have it on screen at the moment, but you go on to set out what you think would have occurred. I think potentially referral to Child and Youth Justice Services, prevention and diversion teams.
Yes, I think things would have gone differently with what we know now, because we would have had a joint Section 47 investigation, I think, which would have involved both the police and social care visiting the child's home.
It involved Acorns and Pressfield?
Yes.
and likely CAMS as well.
Yes.
Potentially a further prevent referral in
Yes.
light of the reference to poison.
Yes.
This was an opportunity for Lancashire County Council to identify the very serious risk that AR posed to others and to himself, to share that information with other agencies and for steps to be taken to address it, wasn't it?
It absolutely was an opportunity for the police and for us to do a joint investigation.
We've spoken to the police about
Agreed.
this. I'm asking about your role, your organisation's role. It was an opportunity for, on the information that LCC had available to it, for that information to be shared with other agencies, the risk identified and steps taken, wasn't it?
Yes.
Do you think that what you say at 2:12 adequately reflects the consequences of this failure?
I think it reflects what we knew at the time when I wrote it.
It would be right to characterise this as an extremely grave failure on the part of LCC, wouldn't it?
It was a failure.
It was not just a failure, it was an extremely grave failure, wasn't it?
Yes.
It fell a long way short of what was acceptable in this context.
I think we've covered that it was a failure.
Ms Anderson, I'm asking because, you're speaking as LCC's corporate witness on children's social care. As you say, as a result of the evidence heard in the inquiry, you now have a broader and wider perspective on what happened. Is there anything else you want to say about that failure?
I would love if you would ask me that after the break.
All right. If we could take 15 minutes, sir.
Certainly. I'll sit again at 25 past. So I think you wanted to provide the answer.
I did. So I believe that Lancashire had an opportunity to convene a multi-agency risk assessment, which with what we know now, would have made a huge difference to what happened in the future. We absolutely take responsibility for our part, and we want to say sorry, and I want to say sorry.
Thank you.
Thank you.
The last period where CSC had any involvement, Ms Anderson, was in May 2022, and that was after police made a further safeguarding referral following AR throwing food around the house, flooding the house, causing the electricity to short circuit, all in the middle of the night as part of a dispute over access to a laptop. You're nodding. I sense you're familiar with it.
Yes.
Sir, for your note, LCC 30170.
Thank you.
That was assessed by the MASH. It looks like without reference to what had happened 2 months before. Is that fair?
Yes.
And I think while it was still being dealt with by the MASH, there was further concern expressed by Presfield School about AR's refusal to attend school, and this, of course, was just after the transition, and also his behaviour at home. which they described as pouring milk into father's bed to prevent him from sleeping, tipping dad's dinner over his head, and pouring water over dad's laptop, which has caused it to break. Again, so just for the note, LCC 30165.
Thank you.
Ultimately, this episode was closed by the MASH on the basis that there wasn't any consent from the parents because they didn't respond to communications. Pressfield followed it up with a formal referral rather than just the provision of information. But it doesn't appear to have been taken forward. Is that fair?
Yes.
And the case was closed at level 2. By this stage, of course, level 2 means neither CFW nor CSC involvement. Can you help us with why that was the outcome in that case?
So I agree that we didn't have what we would have needed to override consent. That said, because of our interactions with the family already, it's my view that we should have chased consent. We could have asked a worker to go out and knock the door and ask for consent. We do that now, and I think we should have done it then.
Moving forward to March 2023, by this point, Pressfield expressing very serious concerns to a number of agencies about the fact that they haven't seen AR since May 22, and no professional has seen him since January 2023, and AR's parents are refusing to allow them in, saying that if they do, they will pay the price. Thinking about where matters reached in March 2023, it must follow, mustn't it, that had there been the chance to intervene earlier in that process in May 22, that would have been beneficial.
Yes.
But Pressfield were now raising the issue again, again LCC 30186, and again there's attempts made to contact the parents, but they don't respond to a number of telephone calls over a couple of days. And the episode is closed then on the 23rd of March, the day after Pressfield's referral is received, saying it doesn't meet threshold for Section 47 and there's no consent. Again, should we take it that your answer to what should have happened on that occasion is similar to what should have happened in March 22, that really, although there is nothing to indicate, let's open a Section 47, let's override consent, there should have been more done given the history of the case to understand what was going on here?
Agreed.
That's perhaps particularly the case where there's a difficulty with parental consent in this context because it's the parents who are refusing to allow the school into the house in the first place. That rather suggests that relying on the parents to consent might not be the most appropriate way forward.
It is, but without threshold for Section 47, so without risk of significant harm, which we've established, we don't have.
It's a difficult one with risk because, of course, nobody knows what's going on behind a closed door. But where you have a child who hasn't been seen for, by this point, 2 months, is it unreasonable to think that there is reasonable grounds to suspect they may be suffering or likely to suffer significant harm?
So we would need more than that. So if we were to go to the police, so if the only way to get into a house is with the police, and we would need a higher threshold than this to get us through the door. So parents and families have the right to not have state intervention, as I know that you're aware. And we have to have evidence of experience significant harm or likely to experience significant harm to force parents to let us in. And I just think, just recording some of the information that I've shared earlier, just with regards to the number of children that don't go to school and the number of children that are severely absent, not seeing a child for this amount of time, that on its own, for a child of this age, doesn't give us significant harm.
Thank you. And again, to be fair, Pressfield had approached the police, who had declined to become involved at this point.
Yeah.
Because this is the last occasion when there was any direct contact in CSC with AR and his family, there's obviously a later episode with CFW, because in fact what happens is Alfonso does contact the MASH after they write to say, "We're here if you need us," my paraphrase. Yeah. But because this is the last occasion where CSC had that kind of contact, or the MASH, can I just invite some overall reflections? One way of looking at the various contacts that the MASH in particular, but also CSC, have had with the family, is that the risk is consistently either underestimated or downgraded, transferred to a lower level than it should have been. There's, other than after the hockey stick incident, there's no examples of the case being moved up. Is that a fair characterisation?
So I don't agree with all of that sentence. As I've shared throughout the conversation today.
It might be thought to indicate that the MASH and the CSC are applying too high a level of risk, but again, for the reasons you've explained, you wouldn't accept that.
Exactly.
We obviously know that there were very many referrals into the MASH at various stages by different agencies. Is the fact of repeat referrals something that's given weight when considering risk?
Yeah, so we now, and for a number of years, if we have more than 3 referrals, we always undertake an assessment in the MASH. We do receive a lot of referrals that don't meet level 3 or 4, and so we do have to be careful with that, but we always undertake an assessment at 3 referrals now.
Thank you. But that wasn't something that was in place in the life of this case?
No.
If I could just deal very briefly then with the final episode, where at the end of the final episode of CFW support. As I've said, AR's parents did make contact in April 23. There was then early help support for them through to September 23. But at the end of that episode, it was agreed by all agencies involved that AR had serious ongoing needs, but that they were unable to work out a way to engage him, and the case closed to CFW as a result. And just to remind ourselves, he was refusing to leave the house, he was refusing to engage with CAMS despite apparently very severe anxiety, he was refusing to attend any form of education. The only way his school, on which he was on the roll, could ensure he was safe was to attend with a police officer, otherwise they were being refused entry again, and he was engaged in no constructive activity whatsoever. Ms Ashworth this morning took the view that at the very least this should have been discussed as a case for stepping up, but said whether or not it would have gone on to meet thresholds determined by level 4 would be another matter. Ms Williams' evidence last week as the family support worker who was engaged in that episode was that she didn't think to do that because she didn't think it would have met that threshold. First of all, do you agree it was something that should have at least been discussed at that stage when CFW have run out of options? There are serious unaddressed needs that no one can work out how to engage AR on.
So I think given some of the information I've shared earlier, just with the level of complexity, the degree of complexities and difficulties that children face, that list is a huge list. That said, most of the children that we work with in children's social care have greater needs than that. That said, The other thing that was really important for me here was his age and him being 17, and therefore his consent and his willingness to work with us. So from a children's social care perspective, outside of Section 47, we wouldn't have been able to force him to work with us either. And so I just think that's a really important thing to think about when we think this through.
Can we take it from that that you agree with Ms Ashworth that this was something that should have been discussed, but also perhaps agree with Ms Williams that it was not necessarily a case where, even if it were discussed, there would have been anything you could have done?
Agreed.
Stepping back and thinking about that long list of needs, and of course also the wider history with which we're all familiar now, is it concerning to you that there would have been nothing that could have been done in that situation? Does that not suggest something of a gap in powers, capabilities to take action?
It is really concerning to me. I really hope we find some different answers.
It's appreciating that you have to work within the statutory structure that exists, but the effect of it in this case is that serious risks or needs that everybody could see simply had to be left unaddressed.
Would you, I'm not sure what I'm saying yes to there, sorry.
Well, would you agree that the effect of it, the effect of the scheme in which you have to operate, was that there were serious unaddressed needs recognised by the agencies who were involved, but with no way to address them?
Yes, I think that there is a real question for us around how we help children with special educational needs and autism who struggle to access the community to have the right services and interventions that reintegrate them into our communities. I think you've talked about the role of CAMS and helping us with a formulation that will help us help those children reintegrate into communities. And I think we do need a system that enables us to meet that need. And I also think we need to find a way to be able to monitor the risk that might be happening in private, in a home, in a bedroom, and those are big questions for the state.
Yes. You set out in your statement, Ms Anderson, at paragraphs 213 onwards, some of the reviews and improvements that have occurred. I'm going to take those as read, if that's all right. I did want to come back to one point that you raised earlier, which was from 2022 onwards. You referred to changes to how risk to others is held in a multi-agency context. And you pointed out the MASPs, which I think is multi-agency support panels.
Thank you.
Am I right that that is a result of the serious violence duty that was introduced in the Police, Criminal Courts and Sentencing Act 2022?
Yes.
That's not a topic that's covered in your witness statement. Could I ask that you, in conjunction with your legal team, put together something for the inquiry by the end of the month?
Yes.
To set out what those are, how they work, and the risk that they're intended to address now.
Yes.
Thank you.
I will add to that the pilot that's happening at the moment in terms of prevention panels, which to me looks like MASPs with a little bit more teeth.
If that could be covered as well, then that would be most helpful. Before I see if anyone else has any questions, Ms Anderson, do you have anything else you would like to say?
I'd like to say that I think the work of this inquiry is incredibly important. LCC and me as an individual want to do the best that we can to make sure that this never happens again in England. And I hope that you come to some great recommendations that will help our multi-agency system ensure that no other families have to experience what these parents have experienced.
Sir, do you have any questions?
You're nearly there. Just one final thing from me. Could we have LCC 001900 up on the screen and page 16? And could you expand the part in red down the bottom, please? Now, make it clear, this is not a trick question, right? When Mr. Goss took you to this, and in particular focusing on the high risk of harm to others, high risk of harm to others, you very understandably wanted to place the question he was asking in context. And the context was that historically, the work of agencies such as yours has been to focus on risk to the child, or young person, not the risk that they may pose to others. And I think that has been a very clear theme of your evidence, if I may say so. Of course, you will follow instructions such as this as to the test that's to be applied. I completely understand that, and I'm not for a moment questioning it. But in terms of how situations like this realistically can be addressed, do I detect strongly from you that you think, given all of the other responsibilities that your organisation and brother and sister organisations have, having the additional responsibility of having to assess and then take action in relation to the risk of harm that the child or young person presents for others, is a difficulty?
Yes.
Now, don't say yes just because I've asked the question.
No, I couldn't have put that better myself.
Right. Because I have a sense that it would only be, for instance, in the very rarest of cases, if at all, that children would actually be removed from the home and placed into care as a result of a process that had assessed them as posing a high risk of harm to others.
That's under Children Act legislation,
Exactly.
yes. Yeah.
Fine. And if you were able to express a preference, you would be saying that although social services should contribute to the process of assessing the risk, actually what you do with it should be left to other organisations.
I think it's a criminal matter.
Yeah. Your evidence has been very helpful. Thank you very much for coming.
Thank you
You're
very
now free
much.
to go.
Thank you.
If we could call Ms. Coombs, sir.
Certainly. Could you remain standing for a moment?
I swear by Almighty God that the evidence I shall give be the truth, the whole truth, and nothing but the truth.
Thank you very much. Please have a seat. Yes, Mr. Goss.
May it please you, sir. Could you give us your full name, please?
Helen Ruth Coombs.
And if we could have LCC 201856, please. Is that your statement for the inquiry?
It is.
And you've signed it on, I think, the 12th of September this year. Are the contents of it true to the best of your knowledge and belief?
Yes.
And if I could also introduce, we can have LCC 201805. That's the witness statement of Suzanne Walmsley, signed the same day, 12th of September. Obviously, I'm not asking you to adopt that as her statement, but are you familiar with that document?
I am.
Ms Coombs, if you just want to try and keep your voice up a little bit, it's a large room and the sound can disappear somewhat. In terms of your experience and role, that can come down from the moment, Sarah. You're the Director of Adult Social Services at Lancashire County Council and have been since December 2024.
Correct.
You were previously a qualified social worker and you've been a Director of Adult Social Services in various local authorities for, I think, the past 10 years.
That's correct. I'm currently still a social worker.
Thank you. I think your statement might suggest otherwise, but thank you for the correction. Just in terms of the role of adult social care in this case, we know that there was a referral made to what's called the transition team in February 2022 by Louise Lewis of Child and Family Wellbeing Service. We've heard a great deal about children's social care. Am I right that adult social care is essentially the process of providing and administering the support that someone above the age of 18 might be entitled to under the Care Act, the Mental Health Act, the Mental Capacity Act? Those are probably the three main ones.
Correct.
And because there is an obvious potential issue at the point somebody moves from the social care that is available to them as a child to becoming an adult at 18 and the care that may be available to them beyond that point, the adult social care team runs a transition team.
Correct.
That is, I think, staffed by qualified social workers.
Qualified social workers and 4 unqualified workers to support.
Who can refer into that team?
Children's services, education, health services, the public, the family, and the individual themselves.
It's a broad approach to who can refer in. Ms Williams, who was a family support worker within Child and Family Wellbeing Service, told us last week that she was of the understanding that a child needed to be open to children's social care for a referral to be made to the transition team. Was she mistaken about that?
She was.
What sort of age is it appropriate for a referral to be made to the transition team for a child?
You would start to think about commonly referring from the age of 14 for 2 reasons. One, because at the age of 14, you will start to understand, particularly if a child has got significant disabilities, the length of time that they'll need to be worked through in terms of post-16 options, particularly if people have continuing health care from the NHS and social care support. But between the ages of 16 and 18 is when the detailed planning would start to commence. In addition, the family, particularly, would need to be supported to understand the difference between having eligibility for adult social care and the arrangements that surround that.
When you say detailed planning would start to commence, is it right that one of the first stages within that is a Care Act assessment?
So there are 2 parts to the Care Act assessment. The first part is an understanding and an assessment about will information, advice and guidance, both to the individual and the family, be the first step before you go into a full Care Act assessment? But yes, the second part is to complete the Care Act assessment.
And it seems that it was the practice in LCC's transition team that where referrals in were received, as you say, from the age of 14 or so onwards, that work generally wouldn't take place until the individual was near or just after their 17th birthday. Is that in accordance with good practice in transition teams?
No.
One issue with it might be that it creates something of a challenge if the situation has changed between the point of the referral and the point the assessment is carried out. There's going to be a good deal of ground that may need to be covered. Are there any other issues with that as an approach?
So one of the main areas that as children move into adulthood and become young adults is that you're switching to the voice of that young person, and particularly allowing enough time to do advocacy, to make sure there are individual opportunities for that person to contribute to their assessment, but also to do the liaison work with other agencies. And for all young adults, there's a lot of change that happens between the ages of 16 to 25. If you have disability or you have a whole range of family circumstances, it's really important that you allow enough time to do that work.
One other important factor for anyone carrying out an assessment of what needs somebody might have as an adult on the transition from childhood is they ought to have access to information about that child. Is that fair?
Absolutely.
I put that very generally, but I'm thinking here of the fact that as of July 2024, the transition team didn't have access to the children's elements of the liquid logic record system. Is that right?
That's correct.
That was a significant and obvious shortcoming. Is that fair?
It was.
I think that is now one that has been rectified so that they do have the ability to read the notes on both children's social care and the early help module.
That's correct. And also to be able to link the family, so it's understood all the different interventions, including carer support.
Thank you. Ms Walmsley, in her statement on page 12, sets out serious resourcing concerns in the transition team in late 2023. She describes excessive caseloads which were becoming increasingly unmanageable and significant understaffing due to long-term sickness and people leaving the team but not being replaced. Recognising that you joined LCC in December 2024, would you agree that's not an acceptable state of affairs for a team to be under that much resourcing pressure?
Yes.
It's inevitably going to have an impact on the quality of work that's carried out?
That's correct. The referrals were being allocated rather than necessarily being notifications at some point somebody might need to, the work needed to start. So they had 50 to 60 cases, but some of those young people might still be only 13 and 14. So we had caseloads which were were not correctly allocated. Normal practice would be to make sure that the manager was looking at the whole work of the team and prioritising it correctly, rather than allocating it onto a caseload.
Yeah. But that doesn't appear to have been happening
No.
in this 2023 period. Is the situation now different?
It is.
Just give us an outline of how.
So the business process, if you like, has been completely refreshed, so that when notifications are made, there is huddles where the whole team looks at the timing in which that person might need to be seen, looks at risk, looks at prioritisation, and the team managers are very actively managing the caseloads so that we're in line with the rest of adult social care. You ideally wouldn't want a social worker actively working with somebody. You wouldn't want them to have more than 25 to 30 cases at any one time. You certainly wouldn't want them to be having 60, and you certainly want them allocated to people that they didn't need to be seeing at that point. Thank
you. Can we turn to the referral itself, LCC 201810? This is the referral that was made on the 8th of February 2022, as I say, by Ms Lewis. Overall, it provides relatively limited information about AR. Is that a fair characterisation of it? It doesn't, for example, attach his EHC plan, which we know he had. It doesn't talk about AR's forensic history or any risk to others. There's no space for that specifically on the form, but it does, for example, talk about his fractured relationship with his father, but without going into any more detail than that. It doesn't, if we go over the page, and I think if we go over one more, yes, it doesn't, despite a prompt, include contact details, save for the CFW worker, for any of the other professionals who've been involved. Not perhaps the most helpful referral for the transitions team to receive.
Not the most helpful referral for the transitions team to receive. However, our objective under the Care Act is to do two things. One, identify the interventions we can do to prevent the need for care and support. So for post-16 options, how do we get somebody into employment? How do they have meaningful activity? What is the family support there? And the second is to do the Care Act assessment. So there are some things in here that you would expect an adult social worker under the Care Act to explore further. Just because there isn't something on a form doesn't necessarily mean we shouldn't be taking it into account.
Thank you. This referral, I think, was assigned to Matthew Embley in February 2022. Mr Embley then left LCC in August 2022. I think it's right, there'd been no work done on it in that period.
That's correct.
For some of that period, Mr Embley wasn't at work. Were there supervision or cover or reallocation arrangements in place for those kinds of circumstances?
There should be, but this again reflects the dangers of allocating people, allocating cases when you know that people haven't got the capacity to do it.
I see. We might also bear in mind that at this point, AR would still have been 16 years old, and in line with the transition team's practice at the time of not particularly picking up a case till 17, it may be that even if he had been in work, nothing would have been done.
That's correct.
It's then reallocated to Miss Walmsley on the 10th of August 2022, and she set out her dealings with it in her witness statement. I'm not going to take you through line by line. Her first substantive dealings with it aren't till over a year later, on the 14th of August 2023, just after AR's 17th birthday, when she begins trying to arrange a Care Act assessment with AR's parents. Should there have been something done with this earlier?
Yes.
How much earlier?
Given our relationship with the family, what we knew based on this transition form, it was always going to be quite a lot of work in order to engage with him as a young person, to access advocacy, to make sure that there was opportunities, particularly given us needing that independent voice to do this work. So it was never going to be a quick assessment. And I'll go back to one of our jobs is to identify whether through information, advice and guidance and support, looking at post-16 options, we can prevent the need for long-term care and support. It's a core part of our wellbeing duty.
The first visit that Miss Walmsley conducts doesn't take place till 9th of November 2023. She set out some of the personal reasons in her witness statement why that took some 3 months to arrange. Notwithstanding those, would you have hoped that even after the point she first picks it up in mid-August 23, that a first visit would have happened sooner?
Yes.
In terms of her preparation for the assessment, she very candidly accepts she didn't review the child and family assessment from September 2021 that had been made available to her. She didn't access any notes on the children's side of Liquid Logic, and indeed she wouldn't have been able to do so. There was a telephone call with Alfonso 2 days before, and there was some limited contact with the SEND team within LCC, and some discussion with another transitions team worker who had been involved with the family. This was by no means sufficient in terms of preparation for carrying out an assessment on this child, was it?
Yes and no. So I think it was important that she did go out and visit and make that first contact, because you also need to be able to meet the family and just physically see the environment. But I think that would have had to have been followed very quickly with then further work done. And that wasn't completed, as we know.
So it might be appropriate to do an early stage visit to the family to take the lay of the land, but what isn't acceptable is to not do the follow-up work, not read the previous assessments, not engage with the other agencies that are involved in depth. And because that didn't happen, this ultimately was inadequate preparation.
Correct.
And if we think briefly about what was not known as a result of this by Miss Walmsley, she wouldn't have known about the most recent episodes of CFW contact because the referral had come before that final episode. She wouldn't have known about the missing from home episode in March 2022, again came after the referral. She wouldn't have known AR's forensic history, which wasn't mentioned on the referral. She wouldn't have known about the prevent referrals that weren't mentioned on the referral. There were enormous gaps in her knowledge of this case.
Correct.
In terms of her visit on the 9th of November, she spoke to AR's parents, but she didn't speak to AR as he was too anxious to see her. I think the position is that it's not a mandatory requirement that a young person is seen for an assessment, but they do have to be involved in it in some way. Their voice needs to be heard. You're
Correct.
nodding your head. And so refusal by the subject of the assessment to engage should lead to consideration of how to proceed. Potentially you're looking at a multidisciplinary team discussion, a capacity assessment, some sort of steps to try and engage the young person, even if they refuse to be seen face to face.
Correct, and that's standard practice for us.
But none of that happened in this case.
No.
Ms Walmsley makes clear in her statement she wasn't aware of any history of violence or aggression, any risk to the wider public or inside the home, and wasn't told anything about that by AR's parents. And she's accepted that her exploration of the case was inadequate. Would you agree?
Correct.
Had she been aware of those factors, she says she would have referred the case to a line manager and looked to contact children's social care. At the very least, this might have enabled a broader, more holistic view of AR's circumstances, even if the conclusion was that any risk of harm was historic rather than ongoing.
Correct.
Nonetheless, on the basis of her visit and her discussions with the parents, she reached a view that support under the Care Act would be available, primarily around AR's isolation. I think you think that was a premature decision to reach, first of all.
That's right.
I think potentially you disagree with the substance of that decision as well. If we could have paragraph page 15, paragraph 71 of your statement up, please. 1856, Sarah. Paragraph 71. You say, whilst he was identified to have needs, at this time he did not present as a priority or someone with significant needs because of factors including, but not limited to, he was housed, he lived with parents who cared for him, he wasn't exhibiting mental health needs such as schizophrenia, etc. No issue over him being housed, lived with his parents who cared for him. Does that perhaps give rather too little weight to the very fractured relationship that's apparent from the records between him and his father?
I don't think so. At that point, we would be wanting to understand what did he want, which is why I keep referring to our duty to prevent the need for care and support. So the outcome, his outcome and his voice, advocacy, do you want to continue living with your parents? Are you looking for supported living? What is it that you're trying to achieve in your life? Because what the Care Act says is that we must be really clear about one or two outcomes must be identified that a person wants to achieve and that it will be significantly impaired. And at that stage, based on the information, we believe, I could see that he did not have Care Act eligibility. That doesn't mean that we didn't need to prevent the need for care and support. Obviously, there's far more information now available.
I see. When you say not exhibiting mental health needs such as schizophrenia, etc., he was obviously displaying signs of apparently very severe anxiety. Are you drawing a distinction between schizophrenia as a major mental illness and anxiety as a different kind of condition?
So I'm drawing the distinction between the only power that we could have used was and could consider is the Mental Health Act. In the adult world, we often have to consider harm to others as well as to self. And we need to consider very clearly which powers we can use. And the reason that specifically talked about mental health needs such as schizophrenia is at this point there was no reason for Suzanne or anybody else to be thinking about the Mental Health Act could have been used in any way, shape or form. That information wasn't there.
Whatever the outcome of the assessment then, your view perhaps being that this was a case that needed to be dealt with more by way of looking to prevent the need for Care Act support, Ms Walmsley's being that Care Act support would be available. What would you have expected to happen following an assessment?
So, providing being eligible under the Care Act doesn't necessarily mean that the only option is to provide a package of care.
It's my fault because I think I have asked too broad a question. Would you have expected the outcome of this assessment, whatever it was, to be taken back and discussed with a manager?
Absolutely.
Would you have expected there to be further professional engagement between the transition team and the family? Again, whether that is as part of looking to put in place a support package or whether that is part of looking to prevent the need for a support package, further professional engagement between the transition team and the family and AR himself?
So I would have expected further professional involvement with the family. I would have expected access to advocacy, self-assessment options, and I would have expected further liaison with all the other professionals involved, particularly our health colleagues as well, and with the wider adult social care team. We have mental health teams, we have learning disability teams, we work, this is our space, and those are the things I would have expected to happen.
And that engagement could have taken place even though AR was not yet 18.
Absolutely.
In fact, what happened is, although Miss Walmsley undertook multiple supervision sessions with her line manager between November 23 and July 2024, none of them identified that the visit hadn't been written up, that the assessment hadn't been completed or had been completed prematurely, and that without seeing AR, and that follow-up was outstanding.
Correct.
Just dealing with note-taking, LCC 201567. This, I think, is the notes that Miss Walmsley made in the assessment itself. They're typed up onto what's referred to as a face assessment. Those might be adequate if they are then supplemented immediately after the event, bearing in mind these are notes being written in the address, but they are quite limited in terms of content, aren't they?
Content and his voice.
I think we have confirmation at LCC 201831 that there were no handwritten notes taken, so these were the extent of the contemporaneous notes.
Correct.
They weren't written up into any sort of fuller form until after the attack took place on the 29th of July, were they?
Correct.
And at that point, there was a process whereby these notes appear to have been supplemented, and then an entry was made onto the Liquid Logic adult system, LCC 30438, page 3, which then had a further note appended to it saying, this is a retrospective entry.
Correct.
First point, it is obviously seriously inadequate that notes of a visit were not written up at all until more than 7 months after the visit took place.
Correct.
The fact that it was prompted by the attack means we can have no confidence at all that it would ever have happened but for that.
Correct.
And though clearly there was an attempt in making the entry on the system that flagged this as a retrospective entry to convey the true position, I'm not suggesting anyone sought to suggest that they had written up a note or had taken actions that they had not in fact done. It is far from ideal that there was this process of notes being written up, entries being made in the aftermath of an attack where it would have been clear that what had or hadn't been done was going to be the subject of scrutiny.
Correct.
There should have been a rather more considered and structured process to preserving and recording the information that was held at the time, rather than the slightly ad hoc approach that appears to have been taken. Is that fair?
And there is now a clear and structured process.
Thank you. The course of events here represents not only failures on Miss Walmsley's part, but also on the part of her supervisor, Emma Clough, doesn't it?
It does.
Miss Clough, I think, had been appointed in October 2023 as a team manager, having only been a registered social worker since May 2022. That's quite limited experience to be a team manager, to be in that role. Is that fair?
It depends on the experience somebody has had before.
The fact that the supervision system as a whole was not picking up the failings in this case is concerning. There ought to be a process by which outstanding actions, inadequate assessments are picked up, even if the supervisor doesn't pick them up. Is that fair?
So there was a supervision policy in place. Was there a system and process that put all the checks and balances and brought all that together in one place? No.
And there should have been, and I suspect you are going to tell us that there is now.
Yes.
Putting it quite starkly, other than a single visit on the 9th of November 23, which wasn't written up until after the attack, the engagement of the transitions team achieved nothing as regards AR.
Correct.
I think there have been 3 different reviews undertaken of this, and you set them out in your witness statement. There was a practice review summary and action plan. There was a report on the LCC 30435, sir.
Thank you.
A report on the transition team's involvement with AR, LCC 30462. Those quite shortly after the attack, and they led to various elements of remedial work around existing caseloads and retraining.
Correct.
And then I think you commissioned an independent management review from an independent social work consultant, Mr. Adams, which reported in March 2025, and we have that at LCC 201954, sir. Why 3 separate reviews, please, Ms. Coombs?
I think the first review dealt with some of the very technical issues and focused on the immediate actions that needed to be taken. I think the second review started to talk about the lessons learned and reflections and how to manage particularly some of the practice issues. I wasn't satisfied that I had assurance that all of that work had delivered some of the changes, and I wasn't satisfied that I completely understood the rationale for not just the immediate issues that needed to be, but where's this whole service going? And in particular, I also wanted to understand and be assured that we'd dealt with all of the individual practice issues in the context of the regulator.
Yes, because I think it was only after the 3rd review that any consideration was given to any referrals to Social Work England.
Correct.
Obviously, and I think a referral has now been made to Social Work England in respect of Ms. Walmsley. Wholly a matter for Social Work England, of course, how they handle that. But that, I think, was not made until July 2025, some 4 months after Mr. Adams recommended that it be considered. Why was it almost a year before there was any referral and almost 4 months after Mr. Adams' recommendation that contact was first made with Social Work England?
So I can't, the original decision was that it would be dealt through management action. And I needed the opportunity to reflect and understand the rationale behind that. Once that was completed, it was also really, really important that if further incidents happen, things go wrong all the time, we can't always predict what will happen, but it's really important that our social work teams are able to embrace the culture of learning. I was very aware that in order to overturn that management decision, to work with this team who is currently going through a significant change in terms of culture and practice, they're now called a young adults team, that how I did it was as important as what I did. And also to make sure that Suzanne herself was supported and enabled through this process. So I make no apology for the fact that it was done very carefully, it was done in a manner that doesn't mean that practice now people feel that there will be necessarily a very punitive, reactive approach to them, that when we do things, we need to learn, but also as registered social workers, and I am still a registered social worker, that it is for the social worker regulator to make decisions, not for the employer, and that we need to refer to them and allow them to help us think and explore where practice might not have been where it should be.
Thank you, I follow. And I ought to say that Ms. Walmsley in her statement sets out some of the personal difficulties she was undergoing at the time she was working on this case. That is in evidence and of course can be taken into account. You've set out in your statement on page 19 from paragraph 89 some of the improvements in this case. We've obviously touched on some as we've gone through your evidence. Ms. Walmsley has also set out some of the changes in the transitions team or the young adults team from paragraph 138 of her statement. Again, those stand as your evidence and as hers. Before I see if anybody else has any questions for you, do you have anything else you would like to say?
So the only thing I would say is that when this statement was written, that was a point in time. The team is now called a young adults team. We have 4 key pathways which are very much focused on how do we support young adults, irrespective of whether they've got a disability, whether they're at risk of harm to themselves or whether they're at risk to others. And we're trying to evolve the way that we work so that those pathways start to walk with young people and make sure that particularly advocacy and working with other agencies is right at the heart of what we do. It is unsustainable for a young person to be living a life that isn't full of aspiration, isn't full of positive work at the point of 16. Care and support cannot be the answer in terms of packages of care and managing people within very tight environments. So we continue to try and work through particularly the risk of things like online for young people who have got diagnosis of autism, and our thinking's evolving around that.
Thank you. Sir, anything from you?
There isn't. Ms Coombs, thank you very much for your evidence. You're now free to go.
Thank you.
Thank you. Yes, Mr Boyle.
So the next witness is Miss Connolly. I know she has kindly expressed a preference to complete her evidence today, and I know you've kindly said you're prepared to sit late.
We'll do everything we can to help.
Grateful for your patience and also that of the other participants.
And then if we need to take a 5-minute break at some stage when the hour and a half
Yes, I have.
point is reached.
I'll ask Mr. Goss to let me know at 4:55.
You just pause for a moment. Oh, people sit down. And then, with the help of the usher, if you could take the oath.
I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you very much, Ms Connolly. Please have a seat.
Ms. Connolly, thank you for waiting patiently. Could you give your full name, please?
Sarah Connolly.
Thank you. Could we have up on screen, please, DSIT, so DSIT 504. Ms. Connolly, do you recognise that as your statement?
I do.
Thank you. We see it's dated the 3rd of September 2025. Is it true to the best of your knowledge and belief?
Yes.
Thank you. Could we also have, please, DSIT 502? Thank you. Ms. Connolly, I think we have a helpful chronology here, particularly of the process of the introduction of the Online Safety Act, which we will come to. Can you confirm that is also true to the best of your knowledge and belief?
Yes.
Thank you. I want to start, please, by asking you about your background. You are, I think, now Interim Director General for Digital Technologies and Infrastructure Group within DSIT, the Department for Science, Innovation and Technology. Is that right?
Yes.
And can you just briefly tell us what that role entails?
I'm responsible for the department's digital technology and infrastructure. That includes cyber, data, and security and online harms.
Thank you. And I think you give us a longer career history. So between 2017, yes, and 2023, you were Director of Security and Online Harms. Is that right?
Yes.
Would that have been with, first of all, DCMS and then moving into DSIT when it was created?
Correct.
Thank you. And then from January 24 to August of this year, you were Director of Digital Infrastructure, is that right?
Correct.
Thank you. Can I ask you about DSIT, please? So DSIT was created on the 7th of February 2023, correct?
Yes.
And is this right? Digital policy was effectively transferred from, as I said before, DCMS, Digital Culture, Media and Sport, to DSIT.
Correct.
And that included, within your portfolio, responsibility for online safety?
Yes.
Thank you. Now, we've heard from Ms Ellsmore from the Home Office and Ms Dixon from DFE. They, I think, have responsibility for areas in respect to the Home Office for online terrorism and extremism, is that right?
Yes.
And obviously DFE for online educational and social development tools, correct?
Yes.
And how does DSIT work together with the Home Office and DFE in these areas?
So we have the overarching responsibility for online safety. They have the specialism, if you like, in those areas, and some others. Home Office does child abuse, amongst other things. It's a, a fairly close working relationship. We would, certainly through the passage of the legislation, have almost daily contact with the departments.
Thank you. I want to ask you now, please, about the regulation that was in place prior to the Online Safety Act 2023 coming into force. So, first of all, the Online Safety Act gained royal assent on the 26th of October 2023, is that right?
Yes.
But as we'll come to, it wasn't actually enforceable until Ofcom had published codes of practice, which took place this year, is that right?
Yes.
So before this year, in effect, the OSA wasn't in force, is that right?
Correct.
Thank you. And I think you frankly accept that the position before the OSA came into force was fragmented in relation to the regulation that was in place.
Correct.
Thank you. That's your paragraph 12. Just to pick up on a couple of elements of that. So there was the EU's e-commerce directive, which I think required platforms to act quickly to remove any illegal content they hosted if they became aware it was on their site. Is that right?
Yes.
And what would the process be for them becoming aware of that?
It could be drawn to their attention by anyone, including law enforcement, but anyone. Once they became aware of it, they then became liable for removing it. Until that point, they weren't.
Thank you. And I think there is some discussion in perhaps the statement of Ms Ellsmore about counter-terrorism policing units which have an online presence. Might they, for example, report illegal content if they found it?
Yes.
Thank you. In terms of illegal content, obviously clueless in the name, that's content that amounts to an offence. Are you able to just give a short précis of what sorts of material that might include?
It could have included anything that was illegal. So it may be imagery, it may be videos. It would have a wide range of meaning. So it may be some terrorist material or child abuse.
Or material that, for example, incited racial hatred?
Perhaps.
Thank you. And is this right? There might be some offences, for example, in a terrorist context where publication or dissemination of the content is the offence.
Correct.
And others where possession or viewing of the material is the offence.
Correct.
So it's perhaps a relatively wide-ranging suite of possible measures, but focused purely on what is illegal.
Yes.
The platform then, if this content was identified to them, could be liable for a criminal defence if they didn't remove it quickly. Is that right?
Yes.
But there was no obligation at that time on platforms to proactively monitor their content.
Exactly.
Were, at this period, platforms doing that to your experience?
Not to my knowledge.
Thank you. There's then a suite of measures under the EU Audiovisual Media Services Directive, which I think was implemented in part by the Communications Act, correct?
Yes.
And that gave Ofcom the powers to regulate video on demand services and video sharing platforms. Is that right?
Yes.
And in terms of video sharing platforms, that did include firms that might be considered social media platforms like TikTok. Is that right?
Yes, though you would need to speak to Ofcom, who can give you chapter and verse on exactly what is included. I would also note that many social media platforms were not regulated in the UK by AVMSD. They were regulated in the EU country that they were registered, which often for social media was Ireland.
Yeah, so I think, is this right, that it only operated for platforms that had a kind of corporate link to the UK, is
Exactly.
that right, to the extent that it was brought into UK legislation?
Yes.
So it didn't then apply to all social media platforms. TikTok was just an example that happened to have that corporate link, is that right?
Very few social media platforms were caught by the EU, by the UK end of it.
Thank you. So there's a list at OFC 506, to the extent that's helpful. In terms of the obligations on video sharing platforms, is this right, that there was an obligation to protect all users from what was called relevant harmful material?
Yes.
So it went wider than purely material that was illegal. Is that right?
Yes.
And that the fact that relevant harmful material came within that provision, that applied to adults as well as children, correct?
Yes.
So there was an obligation, for example, on TikTok to regulate the provision of relevant harmful material and prevent that from being provided to adults.
Yes, that's my understanding.
Thank you. And we'll come on to the position now under the OSA. But I think in addition, there was also a requirement to protect under 18s. Thank you. You set out a further range of legislation and regulation at your paragraph 14. So I'm not going to go through that, but it includes things like the Gambling Commission, data protection, etc. And it might be said that the length of that list does ring true to your suggestion that it was fragmented position before the OSA. Would you agree?
Yes.
Thank you. Within that context, I want please to ask you about two aspects of material that AR accessed. We heard evidence from DCI Pi some weeks ago about the material that AR had when it was searched after the attack. That included the Al-Qaeda training manual, which had been downloaded more than once in 2021. And on top of that, a range of material that related to violence, which included images of bodies, victims of torture, beheading, and also academic material relating to war, weapons, and genocide. So you'll remember that evidence from DCI Pi, which was given on the 22nd and the 23rd of November.
Yes, thank you.
We don't know where, in relation to that material, I think AR obtained it. But to the extent any of it was illegal, steps could have been taken to remove it by identifying it with the website that was hosting it. Is that right?
Yes.
Just one discrete point on this, which is takedown powers. We heard, I think, from Ms. Ellesmore at the Home Office, who said that at the relevant time there was no takedown power. I think this is right, that under Section 3 of the Terrorism Act 2006, police were able to issue and are able to issue removal notices for online content which is unlawfully terrorism related. Is that right?
Yes.
At the time Ms. Ellesmore had written her statement, I think she said that that authority had not actually been exercised. Understanding that this is perhaps more within the Home Office scope of things, are you able to comment on why that hasn't been used?
It is a Home Office matter, I'm afraid. I don't know.
Thank you. So just the reference from Ms. Ellesmore's statement, HOM 4078, paragraph 337.
Thank you very much.
So, in relation to this material, we've covered illegal material and takedown notices. The other question is whether the material was not illegal. And I think you tell us at your paragraph 111 that the way things were at that time, it would have been for the individual platform to assess the content and decide whether it was a breach of terms of service, for example, to continue to host it. Is that right?
Yes.
And I think you say elsewhere in your statement that it's not DSIT's role to assess whether content is illegal. So in looking at this question, that's not perhaps a matter that you can answer for. I think CPS would be the organisation you would expect to bring a prosecution.
Exactly.
Thank you. Much of that content shows extreme violence, but doesn't obviously relate to a terrorist cause on its face. And I think you tell us that merely depicting a criminal offence, that in of itself wouldn't necessarily be an offence in terms of hosting the material. Is that right?
Exactly. It could be a range of things, so news reporting, for instance.
And we'll come on to the video, as perhaps you anticipated in your statement of the stabbing of Bishop Marmari Emanuel, but you tell us at your paragraph 76 that a video of a person being violently attacked will not necessarily be illegal content, even where the attack itself is clearly a criminal offence. Is that right?
Yes.
So is that material that might be called legal but harmful?
It might.
And in terms of that phrase, which perhaps we'll use a bit more, are you just able to expound on what sort of material that might encompass?
It is exactly as it says, anything which is not illegal but may cause harm.
And when we say harm, that obviously includes material centred around violence, and perhaps that's the relevant question here.
Yes.
Are there any other categories that we ought to be considering in the context of this inquiry?
That is probably the major one.
Thank you. And at that time, we've covered the sort of situation for video service providers, but there was no wider system of legislation or regulation in place designed to prevent an adult or a child from accessing legal but harmful material, correct?
Correct.
We'll come on to the OSA, as I've said, but the material AR accessed was extremely disturbing for anyone who has seen it. And it might be thought very troubling that AR as a child was able to access that material without there have been any sort of legal framework or system of regulation in place to prevent that. Would you agree?
Yes.
Just putting the OSA to one side, was there an earlier case for putting in some sort of system of regulation of this sort of material?
I mean, the case was there. The solution was the Online Safety Act.
Thank you. What about the provisions for video sharing platforms under the Communications Act? Are you able to comment on whether there was any thought about making that wider in scope?
By the time that legislation was in force, which I believe is November 2020, we were quite far down the path of online safety. We published a green paper and a white paper, both of which indicated the government's intention to be more fulsome than AVMSD.
Thank you. I want to move on, please, to the Bishop Marmari Emanuel video. We heard from DCI Pi that AR carried out searches on X for the stabbing of Bishop Marmari, and that the Merpol officer who replicated those searches after the attack found that those searches led to videos of the stabbing on X. And I think that the question is whether hosting this video in 2024 was consistent with the fragmented system of regulation that was in place at the time. The first question in answering that is whether the content was illegal, correct?
Correct.
And as I've said, you have, I think, fairly demurred from answering that in terms of saying that it's not DSIT's role to determine whether it was illegal, correct?
Yes.
I think you say that because X decided to continue hosting the video, your analysis is that they determines that it was legal, because it clearly had been brought to their attention. Is that right?
Yes.
Thank you. And as we've covered, because the video might be defined as legal but harmful, we then come to the question as to whether it was in line with X's terms of service to keep it up. Is that right?
Yes.
So at that time, DSIT had no powers, and nor did anyone else in HMG, to remove the video. Is that right?
Yes.
And there was no provision to suggest that X was failing in meeting any sort of regulatory obligations by continuing to host it, correct?
Correct.
After the attack, one of the responses by DSIT and the Home Office was a joint letter which was sent by the Home Secretary and the Secretary of State for DSIT. Was that thought to be the best, can I put it this way, leverage that DSIT and the Home Office had in relation to this content?
Yes. In the absence of powers of regulation, all we could do was ask.
Thank you. And can we have that letter up, please? It's HOM 4092. And it's dated the 24th of January 2025. Just while that's pulled up, are you able to explain why it was sent in January of 2025?
No, I'm not. I'm sorry.
Thank you. We see the letter, just reading the first paragraph. This week, the Home Secretary announced a public inquiry, that might be our clue perhaps, into the failures that led to the Southport attack. As the Prime Minister said, there are grave questions to answer, including how easy it was for the Southport killer to access violent online content in the years and indeed days before the horrific murder of 3 young girls. Could we zoom out, please, so that there's, I think, then a bit of description about the measures in the next few paragraphs about the Online Safety Act that we will come to. And can we look, please, then at the penultimate paragraph and the paragraph below. So there's a reference there to the Al-Qaeda training manual and a reference to the fact that possession of this document is a criminal offence under Section 8 of Tact 2000, and indeed AR went on to be prosecuted for that. There's a request we see, I think, in the last line to swiftly remove unlawful vehicle material on this list available to your services. Is that the sort of notification that should have been sufficient to require a platform to remove material?
The letter doesn't determine that something is illegal, although it is clear that some of it is illegal under Tact. So it would certainly be enough to get the platforms to look carefully at that material.
But what is it that sort of puts the platform on notice formally that they have to take an item down?
It's the clarity about the criminal offence.
Yes, thank you. Could we move over the page, please? And just expands. Thank you, Sarah. So it moves on then to the video of the Bishop Mar Emanuel stabbing. And it says, this video has been removed in Australia following the issuance of a Class 1 removal notice. I think we'll hear from Ms. Carnanisho from X tomorrow, but is this right? That wasn't the ongoing status quo?
That's right. My understanding is that it was removed initially and then came back, was put back up on the platform.
Thank you, and we'll hear about X's litigation in Australia about that tomorrow. The letter goes on, however, it's still available to view in the UK. We are therefore urgently asking you to to ensure this is removed from your platforms, to ensure that it is not used to inspire other attacks. This trial has laid bare the potential consequences of failing to act on such content. We would now urge you to urgently review again the specific content reviewed by Ruda Cabana, sorry, my apologies, AR, and the options available to you to remove all instances of this specific material found to be materially relevant in this tragic case present on your services. So we see there the rationale for urging this to be taken down, correct?
Yes.
In terms of responses that were received from social media companies, do I summarize this correctly? Meta and TikTok replied saying that the video had been removed from their services.
Yes.
So those letters are at HOM 30194 and HOM 30193. I think TikTok also confirmed removal of the manual, and Meta said that it would remove elements of the original Al-Qaeda manual relating to poisons or explosives, correct?
Yes.
Can we have up, please, the X response, HOM 30196? Thank you. So we have the response there. I think if we look at the fourth paragraph, the letter from X says we're committed to being fair, informative and responsive and accountable, ensuring that our measures are targeted and proportionate, and that X takes its responsibility to combat terrorism and violent extremism very seriously. Can we turn over the page, please? Thank you. And I think we see, sorry, could you zoom out? Thank you. Looking at the bottom of the page, my mistake. I think that we see an explanation that the training manual would likely be enforceable under the X's policies, correct?
Yes.
Thank you. And if we turn over the page to page 3, please. Thank you. So, looking then at the response to the footage of the terrorist knife attack on Bishop Mari Emanuel, we see in the second substantive paragraph, last sentence, two sentences. The content reported has not been found to be in violation of X's terms of service. The material has, however, been marked with a sensitive content warning in response to X UK law enforcement requests. And I think we see then the reference to the litigation in Australia, correct?
Yes.
In the next paragraph, thank you. We then see, if we look, same page, thank you, Sarah. I'm looking at the fifth substantive paragraph and below. X has clear policies. We also recognise sometimes it may be in the, sorry, Sarah, my bad instructions. Thank you, that's perfect. We also recognise that sometimes it may be in the public interest to allow people to view posts where this directly contributes to understanding or discussion of a matter of public concern. We uphold it as in the public's interest to view this footage should they wish to do so. Additionally, the Bishop himself has expressed that the public should be allowed to see the footage. And finally, if we could just move over to the final page, we see a thank you for the correspondence and that the letter is just signed from X. You say in your statement that DCIT has a constructive relationship with the major platforms which have the largest reach in the UK. So that's paragraph 129. But would you agree that at least in relation to X, this wasn't an example of that in action?
No, I'm not sure that I would. I'm not sure that personally I agree with what the conclusion they have come to, but they are operating within their own terms and conditions and with the regulatory framework that exists.
So it wasn't a breach of regulation for them to do this at the time, but the letter was actually an attempt to get them to take it down regardless of the regulatory position, wasn't it?
Yes.
And it made reference to the linking of the video to this attack.
Yes.
You said that you didn't agree with the conclusion. Are you just able to expand on that?
Personally, I have seen the video and it is horrific. So I can absolutely understand why the then Secretary of State and the Home Secretary asked X to remove it. So I am deeply sympathetic to that point.
Thank you. From DSIT's perspective, this response was disappointing, to put it mildly.
Yes.
Thank you. It's clear from the letter that this response was not what DSIT was seeking X to do, correct?
Correct.
But was DSIT at that time able to do anything about the response?
No.
Thank you. The letter referred to the sensitive content warning that X put over the video. And we'll hear more detail about this tomorrow, but is this right? That meant that an under 18 shouldn't be able to access the video.
Yes.
Are you aware of that?
Yes.
But is this right? At that time, before the OSA had come into place, there were no requirements on the way in which a social media company had to determine someone's date of birth.
Correct.
And so I think at that time, the measures X had was simply requiring someone to enter their date of birth. Is that right?
Yes.
And we know that although we don't have a date of birth in the meta material, in the X material, we know that AR gave a false date of birth to Meta, in which he said, effectively suggested that he was 18 years old, which presumably would have bypassed the measures in place on Meta.
Yes.
So the response of X in this letter certainly wasn't a whole answer to the risk that children might view this video. Would you agree?
Yes.
Thank you. We've nearly been going for an hour and a half, and that's probably a good time to take a short break if we can. We're making good progress.
Can I look at the stenographer 5 or 10 minutes? 10? Yes. We'll sit again at 5:05.
Ms. Connolly, I think I asked you about the letter. I think we saw that it implies that the inquiry had been announced at that date. I think it also came the day after AR's conviction, so that was my oversight. Can we move on to the Online Safety Act finally, please? You have given very helpfully a long background to the introduction of the OSA in your statement as well as in the chronology. Can I summarise it as follows? There were quite a considerable series of papers and reports from 2017 onwards that raised significant issues with online harms for children and adults, correct?
Yes.
Although it is also true to say that the Online Safety White Paper in April 2019 said that most children had a positive experience online. Is that right?
Yes.
In terms of the steps that were taken to implement that white paper was April 2019. We've already covered, I think, that the Act received royal assent in October 2023. Are you able to help us with the 4-year period from that white paper announcing the new regulatory framework to it actually coming into force?
There was a response, a consultation response to the white paper. There was then a draft Online Safety Act that had pre-legislative scrutiny, and then the passage of the bill itself was long and slightly fraught.
And why was it fraught?
It's a deeply contentious subject, and the issue that we kept coming back to, that Parliament kept coming back to, was the balance between protections online and freedom of expression.
And I think, is this also right? You talk about level of government churn as well, providing a challenge. So I think you say that when Mr. Sunak became Prime Minister, he changed the way in which the Act worked. Do I oversimplify that?
A little. There was churn. There were 7 Secretaries of State between 2017 and 2016 and 2023, excuse me. So obviously each one required briefing, had views. We discussed the policy position with new ministers. That took some time. In addition, you're correct. When it was actually Liz Truss became Prime Minister, the new Secretary of State at that point, Michelle Donnellan, wanted to make some slightly more significant changes to the legal but harmful portions of the Act, which we then worked through and brought in, made the changes and sort of recommitted that part of the Act when Rishi Sunak was Prime Minister.
Putting the political challenges to one side, from DSIT's own perspective, was there anything that could have been done from officials' perspective, do you think, to speed up the process?
I genuinely don't think there was.
Thank you. After the Act came into force, as we've already covered, Ofcom had to provide codes of practice, and I think the first of those codes, which was illegal online harms, came into force in March of this year, and in relation to protection of children in July of this year. Is that right?
Yes.
So we have another almost year and a half for the first code to come into place, and a little longer in relation to children, correct? Yes. But I think you tell us that the legislation required Ofcom to go through a series of steps to put those codes into practice. Is that right?
Yes.
Did DSIT have any concerns about the time that it took Ofcom to do that?
No, we worked closely with Ofcom. It is a challenging regulatory statement. Like, it's very different to the kind of thing that we've done before in this space. So it did take Ofcom some time to do what was required.
Ofcom now has a very expanded role in terms of regulation of online material. Are you satisfied that Ofcom is suitably resourced to be able to carry out its new role?
Yes, Ofcom received 281 million from 2020 to the end of this financial year. We started funding it unusually before the regulatory regime, indeed before the bill was passed, so that it could be prepared. So yes, I think it is well resourced.
From the white paper to the codes being in force was around 6 years. Was that a satisfactory time frame from your perspective?
It would have been wonderful if we could have done it faster.
Of course, this wouldn't have been known to politicians or legislators, but if the Act had been passed around a year earlier, it might have prevented AR from accessing the Bishop Emmanuel video. Is that right?
Yes.
Could we have up, please, Dr. Hyam's statement from Ofcom? It's OFC 502. Ms. Connolly, you've provided a lot of helpful detail about the OSA. I'm just going to Dr. Hyam's statement because it has a brief summary of the measures that are in place in the interest of time. Could we have page 9, please? Thank you. In paragraph 36, if we could just enlarge that, please. Thank you. So this sets out the duties on regulated service providers, just deciphering some of the language that's used here. A user-to-user platform, that would include a social media platform?
Exactly.
Thank you. So it puts a duty on a social media platform for our purposes to assess the risk of illegal content and to put in place proportionate systems and processes to reduce the risk of individuals encountering types of illegal content defined by the Act, and there are certain defined categories of illegal content, correct?
Correct.
So these were the first measures to require a platform to have its own system for detecting that sort of information. Is that right?
Exactly.
And also we see the duty to take that content down swiftly at subparagraph C. Could we move over the page, please? Thank you, and thank you, that's perfect. And then we see some of the measures for children. So a duty for all regulated services to assess whether children are likely to access the service. And then if the service is likely to be accessed by children, to assess the risk of children encountering harmful content. And then we see, I think, 3 duties on social media platforms likely to be accessed by children. The first is to put in place proportionate systems and processes designed to prevent children of any age from encountering certain types of content which the OSA has defined as primary priority content. Just pausing here, this is not illegal content, correct? It is what would be called legal but harmful?
Correct.
Yes. So I think primary priority content includes pornography, content relating to suicide and self-harm, or material relating to eating disorders. Is that right?
Yes.
The next bullet point is perhaps the most relevant for our purposes. Put in place proportionate systems and processes to protect children in age groups judged to be at risk of harm from other content that is harmful to children from encountering it by means of the service. So we have there harmful material which is not primary priority content. Is that right?
Yes.
And within that basket of material, that includes what's called priority content, correct?
Yes.
Thank you. And that includes content which encourages, promotes, or provides instructions for acts of serious violence.
Yes.
Or content which depicts real or realistic serious violence against a person, depicts real or realistic serious injury of a person in graphic detail.
Yes.
Is that right? So the OSA requires platforms to have proportionate systems and processes to protect children from accessing that material, correct?
Correct.
Thank you. We can see from this that the legal but harmful protections are for children, not for adults, correct?
Not quite. You have, we thought of it much more as 3 separate buckets when we talked about, or when we were doing the bill. There was the illegal harms, there was legal but harmful. We then had a separate bucket for children. So you are right that it is legal, but it is worth pausing because the protections, and perhaps you'll come on to this, but the protections around age verification and age estimation apply for children. So we deliberately dealt with it slightly differently from the rest of legal but harmful. It is also worth saying that through the passage of the bill, Parliament was very clear that measures for children were different from legal but harmful.
Yes, thank you. So there was, I think, a lot of political debate about whether adults should be protected from legal but harmful material. Is that right?
Correct.
Are you able to explain briefly the arguments that were at play there?
Freedom of expression. So there was a strong contingent in Parliament and within ministers who felt that for an adult, it was right that they could choose to see something, but that material shouldn't be protected from seeing children by seeing harmful content by the state.
Thank you. So, in the case of the Bishop Emmanuel video, we've seen from the letter that remains viewable to adults on X. But we know that AR carried out the attack very shortly before his 18th birthday. So even if the OSA had been in place at that time with additional age verification measures, it would have become accessible to him within a period of weeks. Is that right?
Yes.
And is that of concern to DSIT?
There was a very clear parliamentary steer as the bill went through that for lots of things 18 is the cutoff when you become legally an adult, and therefore decisions, your ability to decide for yourself what you want to see is sort of rightly, you have the right to choose at 18, and so the same is true in this context.
So I think you talk in your statement about the idea of, was a consideration given to a different position for vulnerable adults, for example?
Briefly.
Perhaps putting it more directly to the context of this inquiry, what about the risk presented by someone who is violence fixated?
Violent fixated is a matter for the Home Office. We didn't, through the passage of the bill, consider that in any detail. We focused very strongly on the 18 cut-off.
One can understand the debate about free speech, but is there the technological capability to consider the position for different approaches to adults of different classes, or that prevent certain risks of harm?
Perhaps, but the devil would be in the detail, I think.
Yeah. And what about persons who might have been already identified as violence fixated?
Again, I think it would depend on exactly what you wanted to do.
So is that something that you think is potentially feasible?
I think I'd want to work very closely with the Home Office to determine what the options were.
And I think you said that that is an area for the Home Office to work on. We know that the Home Office is doing work on violence-fixated individuals. Do you have any awareness of that work?
No.
Thank you. Is that something that DSIT could usefully link in on, do you think?
Potentially.
And is that something you might take away?
Happy to.
Thank you. I mentioned age verification, as did you. So under the Act now, a platform which hosts content which is legal but harmful to children has to have what's called highly effective age assurance in place. Is that right?
Yes.
So that includes age assurance to prevent access to the priority content that we discussed, which would be material depicting or encouraging serious violence or injury, correct?
Yes.
Thank you. And in practice, what does highly effective age assurance involve?
Ofcom has set out quite detailed guidance earlier this year, which says exactly what is included or not. There are broadly two kinds: age verification, in which an age is verified. There are lots of ways to do that, like credit card data, driving licenses. Or age estimation, in which an age is estimated. That technology might be facial recognition or the way that someone moves. It's getting better, but as I said, Ofcom has published two quite detailed documents on what constitutes age verification, age estimation.
Thank you. So previously, as we said, AR simply had to enter a date of birth on X, and I think we'll hear tomorrow that there are age estimation tools used by X, but also can be a requirement for a live selfie or the provision of a government-issued ID. Is that a change that the Online Safety Act has brought about?
Yes.
Thank you. I'm slightly simplifying, well, I think perhaps more than slightly simplifying the Online Safety Act because it has different measures for different sizes of platform, correct?
Yes.
And it's only platforms of a certain size which are obliged to introduce all the measures that Ofcom proposes.
Yes, that is correct. But for illegal content and for children, those duties apply to every platform.
Thank you. And that is to all mainstream social media providers, is it?
Yes.
Thank you. Enforced by Ofcom?
Yes.
Does DSIT have confidence that those provisions are being complied with?
Yes, though you will want to ask Ofcom that question.
Yeah. So in terms of the Act, the duty is to take proportionate measures to protect children from encountering harmful content, correct?
Yes.
It's not to actually stop access.
Correct.
And in terms of Ofcom's role, they can assess whether the providers followed the correct approach, but they're not expected to reach a definitive conclusion on each piece of material, nor substitute their own judgment. Is that right?
Yes.
Are you able to explain why that is the measures that are in place?
Volume and speed. there's a statistic that we used, certainly when the Act was going through Parliament, that 500 hours of footage is uploaded to YouTube every minute. That means that any regulator that is seeking to regulate all of that is bound, we judged, Parliament judged, to be overwhelmed by material. So the Act focuses on systems and processes, not individual pieces of content. But the individual bits of content might indicate a system and process failure, but it was intended to, the Act is intended to, over a period of time, make the internet safer. And the best way to do that was to make sure that those processes worked.
So it creates the framework. It doesn't seek to search out and take down material. Is that right? Thank you. But I think it's also, is this right, limited? Of course, we've talked about social media platforms, but also search services and services that host pornography, correct?
Correct.
So it's those three areas that come within the Online Safety Act.
Correct.
I said before that we don't know where AR's found a large portion of this material, but it doesn't seek to regulate the wider depths, can I put it that way, of the internet.
That is correct. I would just point out, you've shortened user-generated content or user-generated services to social media. You're right, social media is user-generated, but it's not just that. There may be other things.
Can you expand on that?
So any platform that has a chat function is user-generated content. Nowadays, that's quite a lot. So although the focus is the large social media platforms, many companies can fall into scope, and indeed that was one of the areas of pressure as we took the bill through Parliament, whether or not the scope was too large.
So there are, would it be fair to say, significant limitations on the reach of the Act. In your view, is it strong enough to ensure that children are adequately protected from harmful content online?
There are, I'm sure, areas that it could go further. It is the most significant step in the right direction that there has been. We should always look to improve, but it is a strong step in the right direction. And
in terms of looking to improve, what areas are you considering at DSIT?
At the moment, we're focused on making sure that it is properly implemented and it's sort of fully functional. And then as that happens and as new harms inevitably emerge or new technology inevitably emerged, we will work with Ofcom to look at whether or not more powers need to be brought in.
Just keep your voice up. Sorry, I'm guilty of the same. We're late in the day. I have three brief, discrete topics just to go through, please, with you now. The first is algorithms. And so the risk on social media that algorithms push more violent content at someone that has taken an initial interest. What does the OSA seek to do about that?
If they are a child, the algorithm should not push any content that is violent to them. If they are an adult, then there is choice. So what the Online Safety Act does about that legal but harmful bucket is effectively try and give as much choice as possible so that we called it user empowerment tools. The user is empowered through a bunch of choices that are given to them by the platforms proactively to not engage with content. The challenge is, as you have indicated, if someone is inclined to look at it and seeks it out, then the Online Safety Act will give limited protection.
Thank you. The next is virtual private networks, or VPNs. We know that AR used a number of VPNs through the evidence of DCI Pi. And obviously those can be used to bypass geographical restrictions. So they could be used, couldn't they, to bypass the age verification restrictions that have resulted from the Act?
They could.
And so where illegal or harmful content is accessible through the VPN, there's no measure in place to stop that. Is that right? That's
correct. We debated it briefly, it was debated briefly during the passage of the Act. Again, it was felt at the time that adults who wanted to use a VPN should be allowed to use a VPN. And there are circumstances in which the usage of a VPN is perfectly legitimate and indeed may be helpful. even for children, a child trying to look at material to get help from an abusive situation. So there are instances where a VPN might be entirely legitimate.
Can you just help on what those are?
So if you had a child, for instance, there were two different examples. If you had a child who wanted to seek out material but perhaps didn't want a parent to know, fleeing abuse in a family or trying to seek out private information, then there may be circumstances where it is legitimate for them to use a VPN to hide their IP address. The other example that we used, or that was used in bill passage, was around journalists in war zones or otherwise hostile situations who might legitimately want to mask their whereabouts. So
they wouldn't be using it in the UK, would they?
I mean, the example that we used at the time, women fleeing domestic violence, that there may be instances where the usage of a VPN is reasonable. The debate as it went through Parliament was, where did we want to come out on freedom of privacy versus protection from harm? And that is where Parliament came out.
Is DSIT looking into solutions to the ability to manoeuvre around the OSA restrictions, or is the position that that was the conclusion reached?
So I know Ofcom is looking at sort of the usage and trying to do some research into it. I imagine it is something that we will continue to look at.
And obviously, the risk might be that material is accessible to people in other countries. Is there any sort of steps being taken to draw a kind of international consensus or set of measures that might address that?
We talk to a series of countries about online safety and have done for years. The Australians have an online safety system, an e-commissioner. The Irish, there's also EU law, which is broadly in the same sort of space. So we talk to other countries, but not quite an international consensus.
And the final topic was the role of parents. So we've heard about the DFE position and the control in schools, and I think your answer would be that's not a DSIT issue in terms of the measures that are in place. But at home, obviously, it's parents who can play an important role in supervising a child's online use. And I think we can take from their statements that AR's parents suggest that they had very limited visibility on AR's internet use for reasons that will be explored. In terms of the position pre-OSA, there was no sort of regulation or system in place to give parents the ability to specifically take a role in their child's internet use. Does the OSA affect the role of the parent in any way?
No.
And is that something that DSIT is aware of and considering?
We are, yes, is a short answer. Media literacy is a big part of this. Regulation, legislation will, I think, only take us so far. So supporting parents to be aware and be active in their children's use of the internet is important. We will publish a media literacy strategy at some point over the next few months, and alongside that, a campaign to support parents in doing so. So, yes.
Thank you. If you could provide that to the inquiry, that would be helpful. Those are all my questions. Is there anything else you wish to add?
No, I don't think so.
Thank you. I'll just turn to seat.
Yes, Mr. Chapman. VPNs.
Yes.
If a content provider is serving up harmful material, arguably, through a VPN, would they fall foul of the Act?
It would depend, I think, on the VPN, sort of where it was and what it was doing, and was it in the UK?
Well, supposing the VPN is in a very permissive country.
And, but where is... I think the answer to your question is it would depend, but the usage of a VPN, if someone was in the UK trying to use a VPN in a permissive country and accessing other material or harmful material, then there would not be anything to stop that.
But am I right in saying this is a technical problem, that the content provider doesn't know who the ultimate user is?
Correct.
So how could they fall foul of the Act?
I'm not sure I understand the question.
Well, let me do it this way. Supposing you're a child in the UK, you decide to access a VPN in a very permissive country. It's all encrypted, goes to the VPN in the permissive country. That sends a request to the content provider. The content provider just thinks, I'm permitted to serve up content to that permissive country.
Correct.
And I wouldn't know that it's going off to a UK child.
Correct.
So is that a defence under the Act?
No, it's not an offence under the Act.
Sorry?
It's not, no.
Well, how could they be liable if they can't even know where the content's going?
Because they are in another country, I assume, in your example.
Well, supposing the harmful content is in the USA,
It would still not be an offence under the Act.
but how would you prove it? How would you prove they knew where it was?
It's not an offence.
It's not an offence.
It's not,
No, it's not an offence.
No,
Yeah.
There's a no in there.
sorry.
I'm sorry, I missed it.
My voice, sorry.
Understood. Australia was a classic example, was it not? The litigation in Australia. I don't think the material was in fact ever taken down, was it? It was just geo-blocked.
That's my understanding.
Yeah. Is the reality this, that although the UK leads the world in this type of legislation, that it will only be effective so far as other people follow?
Well, I would say that the Online Safety Act has made some changes and will continue to make some real changes to what children or adults in the UK are able to see.
But you saw the outcome of the litigation in Australia, which was that X ultimately prevailed, didn't it, in that litigation?
Yes.
Isn't it right that the content providers are ultimately going to determine what is harmful or not?
Not in the UK. In the UK, we've decided what is harmful for people to view here.
But you take the point about the VPN.
Yes.
Would I be right in saying that big content providers emphasise freedom of expression in general?
By content provider, do you mean the social media platforms?
Yes.
Okay. Some do more than others.
You wouldn't say there's a general tendency, I mean, we hear people like Elon Musk who are very keen on freedom of expression.
Yes.
Yeah. So is the general point true, that they tend to emphasise freedom of expression?
Yes.
And these are often very large companies
Yes.
with large commercial interests,
Indeed.
and they can pay for litigation and lobbying. Yes. All right, thanks.
The debate around VPNs, did that come down to a stark choice as to whether to permit them or not to permit them? Or was it more nuanced than that?
The honest answer is that I don't recall it being a huge part of the debate through Parliament. It was discussed. Certainly, it was discussed with ministers. But it wasn't the focus, I think I would say, of the debate in Parliament.
Okay. We've kept you waiting for a very long time. Thank you very much for your attendance. I think we're now going to rise, Mr. Boyle. Is that right? What time tomorrow?
So 10 o'clock.
Certainly. I'll rise until 10 o'clock tomorrow.